Good morning, Your Honors. This is a continuation of the public panel interview of the candidates for the position of Supreme Court Associate Justice, Vice Honorable Myra V. Lopez, who will compulsorily retire on June 4, 2025. Please all stand for the centennial prayer for the courts.
Almighty God, we stand in your holy presence as our supreme judge. We humbly beseech you to bless and inspire us so that what we think, say, and do will be in accordance with your will. Enlighten our minds, strengthen our spirit, and fill our hearts with fraternal love, wisdom, and understanding, so that we can be effective channels of truth, justice, and peace. In our proceedings today, guide us in the path of righteousness for the fulfillment of your greater glory. Amen.
Please be seated. Allow me to introduce to you the members of the Judicial and Bar Council who are present in today's public panel interview. We have the Honorable Justice Jose Catral Mendoza, JBC Executive Committee Chairperson and regular member representing the retired justices of the Supreme Court. Honorable Attorney Nesauro H. Firme, regular member representing the Academe. And Honorable Justice Erlinda Piñera Uy, regular member representing the Integrated Bar of the Philippines. May I now refer you to the Honorable Justice Jose Catral Mendoza to officially open today's public panel interview.
The public panel interview of the candidates for the vacant position of Associate Justice of the Supreme Court is now open.
Your Honors, the candidates to be interviewed this morning are Honorable Court of Appeals Associate Justice Ramon A. Cruz and Honorable Court of Appeals Associate Justice Maria Elisa S. D. May we request the candidates to please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth in this public panel interview of the JBC? So help you God. Thank you. May we request Justice Cruz to please have your seat in the middle po. And Justice D to please proceed first to the holding area. Thank you. You may take your seat po, Justice. Good morning, Justice Cruz. Good morning po. Your Honors, the first candidate to be interviewed this morning is the Honorable Court of Appeals Associate Justice Ramon A. Cruz. The first to interview Justice Cruz is the Honorable Justice Erlinda Piñera Uy.
Thank you, Attorney Cuevas. Good morning, Justice Cruz. I have two sets of questions, one from the Secretary of Justice. Unfortunately, he's not able to attend, but he has a representative here to listen to your answers to his questions. So I will start with his questions. Number one, you participated in Advanced Skills for Appellate Judges program at the National Judicial College in Boston. What specific skills or insights did you gain from this program, and how have they enhanced your work at the Court of Appeals?
Your Honor, the advanced skills, the participants there were purely appellate justices in the United States. I had an exchange of views with them with our current procedure as against the procedures in different states in the U.S. That for me is a good enlightenment, because you argue with a Chief Justice of Dakota and Justice of Oklahoma and other areas.
Have you picked up any best practices from their sharing?
Yes, Your Honor. I think the best practice there is on transparency, because justices of appellate courts in a particular state, I just could not recall what state there, uh, the justices there give emphasis to the stakeholders of the court that before he gives an opinion or decides cases, normally stakeholders are asked of their respective views.
And you have applied this?
It could, but it would also it would require some procedural changes.
Number 2, you have been actively involved in the Court of Appeals Committee on Rules and other technical working groups aimed at revising procedural rules. What do you consider as the most pressing procedural reform that the Supreme Court should prioritize, and why?
I am no longer, ma'am, a member of the Rules Committee, but I was once a member of the Rules Committee because membership in the Rules changes. There is now a proposal, and I think already submitted to the Supreme Court on the amendments to our IRCA. And I think anytime now those amendments will be approved by the Supreme Court. There are several changes there.
Number 3, you have taught remedial law and criminal procedure at various universities. How do you reconcile the theoretical knowledge you impart to students with the practical realities you encounter as a sitting justice, especially in cases where judicial discretion is heavily exercised?
During when I was still active teaching remedial law subjects, ma'am, the final questions that I would ask my student is to give me a briefer from if it is a criminal procedure of a case starting from the time it is filed with the prosecutor's office until a judgment is issued. My final question really is just one. There is only one question that I normally post, but it kind of would require a long answer because from the time the case is filed with the prosecutor's office until a final judgment is issued, it requires variances and nuances. So it normally would consume around 2 hours for them writing it down. Once you get an overview of the procedure or of the system, you could then notice the kind of discretion that a judge could do in a particular case.
Number 4, it can be said that our Constitution shares some similarities with the U.S. Constitution. As hopeful to become a final arbiter of constitutional issues, can you pinpoint to us one particular constitutional principle that you will strictly guard against being influenced by U.S. jurisprudence, albeit similarities in our constitutions?
How judicial power is defined in our Constitution is what differs us from the U.S. Constitution. But basically, we follow all major provisions in the U.S. Constitution, particularly on the Bill of Rights. But in our Constitution, what differs us from the U.S. Constitution is how judicial power is defined, where courts are given the power to decide cases when the allegation of grave abuse of discretion is alleged. But mostly, Bill of Rights are the same. The provisions of Bill of Rights are the same with the U.S. Constitution, the Equal Protection Clause. We follow it. In fact, we adopt precedents of U.S. Supreme Court.
Number 5, with your long years of practice of law and now as an applicant for a Supreme Court justice position, can you share your judicial philosophy?
It is really kind of hard, Your Honor, to say that I am a judicial activist or one who adopts judicial restraint. As I was saying earlier, there is a provision. The way judicial power is defined in our Constitution gives the court judicial authority to tackle cases where there is an allegation of grave abuse of discretion. So that way, you become, if you decide cases with that as a legal background or as a legal basis, then you become a judicial activist. But then again, there is the doctrine of judicial restraint, where ordinarily, courts do not tackle constitutional question. We avoid tackling constitutional question because enactments or laws have passed the judiciary and the executive. And normally, we give deference to these independent bodies and co-equal bodies. So, depending on the circumstances of each case, I think that the circumstances of each case will define you whether you are a judicial activist or you adopt the doctrine of judicial restraint.
Number 6, do you have a particular justice here or elsewhere whom you considered an idol and why?
He was in front of me earlier, Your Honor.
You have to
But
repeat that
just
when he
went to the
comes back.
restroom. I was his colleague in the RTC of Quezon City and for a short time in the Court of Appeals. I like the way he penned his decision, particularly that case involving the employees of Quezon City Hall, where some employees there would use the space, the basement, as a place for hearing masses. He was the one who penned that decision in that case, and he advocated the principle of benevolence, how to approach a particular case like that. So I think while he is not yet here in front of us, I would say that he is one of my role models.
He should hear that when he comes back. Number 7, assuming you were appointed to the Supreme Court and given the number of years that you will be there, what do you wish to contribute thereto and to the whole judiciary aside from decision making?
If Ma'am, the fat lady sings the song with me and I get appointed there, I will be in the Supreme Court for a little over 2 years. That length of time, I think I would still be doing some meaningful job, albeit short, depending on the cases that are rapported to me. Then I could, in a way, contribute something to the Supreme Court. And also, the Chief Justice has adopted the SPJI. It is a 5-year program from 2022 to 2027. So, by the time it winds up in 2027, I think that would also be the time that I will be retiring. So in that way, I could probably contribute something to that program.
Number 8, in the context of criminal law, how do you reconcile the principle of nullum crimen sine lege, no crime without law, with the rapidly evolving nature of crimes in the digital age, such as cybercrimes and artificial intelligence-assisted offenses? As an indispensable pillar of the criminal justice system, how could the Supreme Court address the matter?
That is actually a great challenge to the court because a court normally is a passive participant in the dispensation of justice. So if there is no law that is violated, then we really could not say that act committed by the actor is criminal. But this is a changing world. there have been several international treaties and agreements entered into, which would tend probably educate us on future laws, particularly one affecting AI. AI is a great challenge, a big challenge to us.
Number 9, the principle of proportionality requires that the punishment must fit the crime. How do you view the constitutionality of mandatory minimum sentences, which limits judicial discretion? And should the judiciary have the authority to invalidate such laws if they lead to unjust results?
If there is a law, a law or principle directing that the penalty really must be proportionate to the act committed, then I guess what the Supreme Court, what the court could do is really impose that law. But there is this principle also that empowers the court to make recommendation to the president how to lessen the impact of the penalty.
Last question. In your view, does the doctrine of presumption of innocence extend beyond the trial stage to public perception and media coverage? And how should the judiciary protect the presumption of innocence in an era of widespread media sensationalism?
Again, Your Honor, there are broadcasters and commentators who I think know better than us. This also has posed challenges to the courts, where some commentators would criticize decisions issued by the court as not consistent with the law and the evidence. But it is just a question of the court following what the law and the evidence would require them to go, and let the media say whatever they want. Because at the end of the day, it is your conscience would be the ultimate arbiter.
So that ends the questions of the Secretary of Justice. I have a few questions of my own. If appointed to the Supreme Court, what reforms, if any, would you introduce to speed up the delivery of justice in the Supreme Court?
I am a member, ma'am, of, I was designated to be a member of the technical working group directed to propose amendments to the rule on criminal procedure. One of the areas which I have contributed is on pre-trial conference, where I suggested, and I don't know if the bank will approve this, I suggested an obligation or a duty on the part of the prosecutor to disclose evidence to the accused which may be favorable to the accused, leading to either his acquittal or the lowering of the penalty that may be imposed. That way, if that is approved by the bank, that would have the impact of cutting short the trial. Because if, say, the evidence that is disclosed by the prosecutor would lead to the acquittal of the accused, then right there and then, the case is dismissed. Or since it is part of pre-trial, if the matter disclosed by the prosecutor is one which will lessen the penalty, that a plea bargaining agreement may be entered into, which would also cut the trial of the case. But I do not know if that will have to be accepted.
Yes, that was supposed to be my next question, whether your proposals have been acted upon. So not
That
yet.
is still pending, Your Honor.
What about, because I see that you are also a member of the TWG on proposal to amend the rules of civil procedure. were you the proponent on the default? What follows after a default by the defendant?
That was long ago.
That there is no need to present evidence ex parte?
I was probably one of those who suggested.
I see. Okay. In your 15 years of experience in the Court of Appeals and 10 years in the RTC, can you share a significant case or legal decision that had a profound impact on you, and why was it so influential?
There are two cases in my 10 years in the Court of Appeals, which until now, I could not easily forget. One is a criminal case where the accused is the husband, and the victims were his wife and 3 children. The husband,
What offense?
the husband was accused with parricide. And trial proceeded, and the husband was convicted by the RTC, and appeal was taken to us. On the basis of the evidence in the law, I had a hard time acquitting him. But that was what the law and the evidence told me what to do. So I entered a decision sustaining the appeal and acquitting the husband.
On what ground?
Reasonable doubt, Your Honor, because
Insufficiency
there
of
was
evidence?
sloppy. It was
Ah.
the prosecution was kind of sloppy.
I see. Any more? You mentioned 2 cases, so what's the other
And the
one?
other one is the writ of kalikasan cases involving that area in Baguio,
Mm.
where I granted a petition for kalikasan to stop the development of the commercial development in that particular area. It was my contribution to environment.
Considering that the Court of Appeals is an appellate court of general jurisdiction, can you describe the different types of cases that were assigned to you or to your division?
We actually handle labor cases,
Yes.
civil cases, criminal cases,
In your sala, I mean, in your division.
all kind of cases.
You
ma'am.
have handled all
Because,
kinds of cases already.
the rappel would include all kinds of cases. Cases coming from the
So all kinds of
SEC.
cases have been assigned to you so
yes,
far.
in the number of years that I've been there.
Yes. And what can you say will be your expertise? What specific field of law do you excel in?
I do not claim an expertise to these cases. We just have to.
Or your favorite field of law, which you can easily decide when you
The
get
easiest, ma'am, is
for
labor cases.
labor.
Because it is just a question of determining the existence of an employer-employee relationship and whether the employee is entitled to reinstatement and payment of work wages, and looking into the factual circumstances of the case. It is simpler than a complicated criminal, or better still, criminal cases consisting of several volumes.
What would be the percentage of labor cases that were assigned to you?
Oh, lately, labor cases count a lot.
Majority?
Yes, Your Honor.
I see. What qualities do you believe are essential for a Supreme Court justice, and how do you embody these qualities?
Madam Justice, my heart and my mind, plus the number of years that I've been in the Court of Appeals, I think, modesty aside, would qualify me to that position.
Can you give me an idea on your working style as an appellate court justice? How do you handle cases assigned to you, pending incidents, monitoring of these
Yeah.
incidents?
Immediately after rappel, I would require my division clerk to look into the formal requirements of a case, whether it is a special civil action. Normally, it would be a special civil action. Then if the formal requirements are complete, then we would ask the respondent to comment. And after the comment is in, and if necessary, and when required, parties respect the memoranda have been submitted, then I would discuss it with my lawyers. I would sit down with my lawyers and discuss with them the nitty-gritty of the case. And until we arrive at a common decision what to do with that particular case. Then we prepare a report, include it in cases for deliberation, and route it to do other justices. We deliberate on it, and if it is, if the two others are satisfied, then we promulgate it. But with respect to civil and criminal cases where the manner of disposing it is kind of different, after the briefs are in, the same, I also would sit down with my lawyers, discuss the nitty-gritty, and until we come up with a common view with how that case would have to be resolved.
What do you think are the biggest threats to judicial independence in the Philippines today?
There are plenty, Your Honor. If you get, if you are easily intimidated by the personalities involved, a simple telephone call will now threaten you to dispose that particular case. So it depends on the kind of stuff you are, how you are made of, how strong your heart is. But there are so many ways of skinning a cat. There are so many ways of approaching a problem. It is just a matter of really approaching it with the heart.
Let me ask you a question on labor law. What is the fourfold test to determine the existence of employer-employee relationship?
That there is control and the manner of how the things are done is with the employer. The results of the actions, the results that has to be submitted, and I think there's another one with respect to the payment of wages. If these requirements are satisfied, then you establish the employer-employee relationship.
Did you mention 4? One is power of control.
Uh-huh.
Second one?
Supervision, how the results are made. Also on the payment of wages.
Right. And what else?
And I think the fourth seems to escape me at this point.
Power of selection and engagement of employee. And the last one is if you can select, you also have the power to?
Fire.
Yes. What are the limitations in the exercise of the power of legislative investigation?
Okay. Congress, in particular, Congress has the power to issue rules to govern their investigation, particularly when the investigation is in aid of legislation. They have control over it. They have a rule. They are allowed to adopt their own rules and procedure. The caveat, though, is that those witnesses appearing before it should their rights to appear before them should be observed by Congress, and the rights to due process will have to be observed. And the right to investigate ends when the Congress terminates.
Are you familiar with the essence of the unavailable child doctrine involving child abuse cases?
Yes, ma'am.
Can you share your
In
understanding?
prosecution for child abuse cases, normally you would need the testimony of the victim, and normally he would be a child. Even if the child is not presented in court, you could still sustain a conviction. Even if the child is unavailable, that is why we call that the principle of unavailable child. So even if the child is unavailable, conviction could still be had if there are other corroborative evidence.
My last question. What is the blameless ignorance principle?
Is that a principle in
Criminal law. If the commission of the offense,
it escapes me too, Madam Justice, at this point.
blameless ignorance principle is if the commission of the offense is not known at that time, prescription begins to run only from its discovery. So that's my last question. Good luck to you, Justice Cruz.
Thank you very much po.
Thank you, Justice Uy. We would like to acknowledge the presence of Associate Justice Ramon Paul Hernando. Good morning po, Justice. Our next interviewer is the Honorable Attorney Nesauro H. Firme.
Thank you, Attorney Cuevas. Good morning, Justice. Ayan, please turn your mic on. So, may I know how many times did you apply to become an Associate Justice of the Supreme Court?
Oh, so many times already.
8 times. And
So
during
many
those
times
8
already,
times,
Justice. And I think I was shortlisted for 7 or 8
7
times already.
Yeah.
So I was telling Justice Uy earlier, until the fat lady sings the song with me.
So, always nominated but not appointed. Yeah.
Well,
Maybe
that's-
this will be your,
That's the harsh
lucky-
reality of life.
yes, it's part of life, not to accept what is given to us. Okay. So if appointed justice as an associate justice of the Supreme Court, what would the stakeholders expect from you?
Nothing special, Your Honor. What I could probably contribute is the hard work that I've shown to the Court of Appeals and the RTC judge. I decide cases within the prescriptive period. I listen fairly to, I read what are espoused in their parties' pleadings and participate to whatever programs that may be or activities that I will be asked to join. As simple as that.
So next question, Justice, how adept are you in using computers in legal research? Because I noticed your decision, submitted draft decision to us.
I
was
did it.
100.
I did it in writing, Your Honor. Well, I do. I am not really completely illiterate. I do sometimes. I sometimes use the computer, but when we were asked to do or to write a decision where you do some research, then I get altogether lost. Where you do your decision writing together, researching the material, the precedents that could be used in the decision.
Would it be much easier if you use computers in researching? You can just
It will take time, but I will. I'm still not that old.
yeah, of course. Okay. You mentioned earlier, Justice, you will be serving almost 2 years if ever appointed.
A little over.
So yeah, a little over 2 years if ever appointed. So, and what are your concrete plans in order to maximize this a little over 2 years, no? In order to dispose as many cases as you have been raffled, or to be more as effective and productive Associate Justice of the Supreme Court?
Well, that is easily said than done. But I think what you really will have to do is prioritize the cases that will have to be rapported to you, depending on the dates when these cases were filed and on the importance of the cases that are pending. Get good lawyers, strive a little harder, do some longer hours, then that would probably deal with the judicial side of the court. And depending on the assignment that the chief will give you, then participate on those activities, particularly the strategic judicial innovation.
So speaking of getting lawyers or hiring lawyers, do you plan to hire new lawyers or probably bring in your lawyers and EAs with you, or are you going to get the lawyers from the Supreme Court?
That the 4 or 5 lawyers that I have are really reliable. So I guess if they want, they would be there.
So I also noticed, Justice, that you once worked with the Planters Development Bank.
Yes, Your Honor.
Yes. I will ask you something about that. And I know you can answer that easily. No? So this is a case of the Planters Development Bank. The facts are summarized this way. For instance, a borrower. Now, you know the transaction with the bank. No? When we obtain a loan, we execute 3 documents. Of course, the contract of loan, the promissory note for the payment of the obligation, and the bank would not allow any loan to be processed unless you put some security. So we execute REM, real estate mortgage. So this is what happened. In the REM, in the real estate mortgage, there is a provision there about notice to the parties. Meanwhile, in the promissory note, there is a waiver of sending of demand letter. So the borrower failed to pay his obligations as they fall due. Thus, the Planters Development Bank foreclosed the mortgage. Of course, the borrower here filed a case for the annulment of the foreclosure on the ground that he was not given a notice, a demand letter. The bank argued that, well, there is a waiver on your PN. But he argued that, look at the REM, there is a notice here. So if you are now to decide that case, how are you going to rule?
In that kind of a situation, Your Honor, the principal contract really is the promissory note. The real estate mortgage is just but a secondary contract. It secures the amount indicated in the promissory note. But I guess because there is a notice requirement in the secondary contract, even if it is just a secondary contract, the bank is bound to inform or notify the borrower of the intended foreclosure that it intends to do. It is just but fair that the bank notifies the borrower of the extrajudicial foreclosure.
Okay, well, interestingly, the Supreme Court said otherwise, and even made a distinction between the notice in the REM and the notice or demand letter as provided for in the promissory note. At any rate, now
It could change.
Yes. Okay. Also, Justice, I was looking at your the decisions that you penned while in the CA. You affirmed in one of those cases the decision of the RTC involving the tenancy agreement. Tenancy agreement.
Yeah, okay.
Yes. And according to you, the trial courts do not have primary jurisdiction over the case. So question is, how would you determine the existence of a tenancy agreement or a tenancy relationship? Sorry.
The tenancy or tenancy agreement between the landowner and the farmer is established by the agreement that they has, that the property is agricultural and that it is devoted to to rice and corn, and the payment and the arrangement that the farmer will have or will comply or will have to do in favor of the landowner.
For instance, this farmer that you're referring to has been cultivating and occupying this portion of land for so many years. Would that create the existence of a landlord-tenant
I
relationship?
think the requirement is that the landlord-tenant relationship, the agreement must be expressed.
No matter how long the tenant is staying in this portion of land.
Well,
and has been
depends on the
cultivated.
circumstances of each case. If, say, the landlord is just or is a neighbor of the tenant and the property adjoins the property, that it could be that the tacit approval of the landlord could not be denied, then that is a matter that could be considered.
So in other words, there is no automatic establishment.
But as a rule, I think the agreement must be expressed.
Yeah. Also, I heard earlier that your favorite subject is labor. Your favorite subject is labor.
No, Your Honor.
I must have misheard it.
The questions posed of me by Justice Uy were all about labor.
Yeah. Sige. This is actually a situation that you can venture into because, well, the Supreme Court has yet to make a decision about it. No? So this is the situation. No? We all know why we do have to distinguish just cost from authorized cost, right? No? Because of the payment of the separation pay. No? Because in just cost, you do not pay them separation pay, while in authorized cost, you have to pay them. And in authorized cost, the law provides for two amounts. 1 month pay for every years of service and 1/2 month for every year of service. Diba? So this is the situation. For instance, there is a hotel. Well, this hotel, because of probably the pandemic, has not been earning, or the occupancy rate has dropped significantly for 3 years in a row. Now, the management decided to sever the relationship or the employment of 10 of its 20 employees. Well, probably 3 out of 6, let's say they are the security guards. So the reason for that is that these 3 security guards can perform the duty of those 6. And let's say 4 receptionists. So 2 of them were removed on the premise that the remaining 2 can perform the duties of these other 2 who were removed. Another 6 probably in the bar, in the restaurant. 3 of them were removed because 3 out of 6 were removed because their works can be performed by these 3. And yung other 4, probably yung service, yung room service. So these 4, 2 of them were removed because their works can be performed by the remaining 2. In other words, 10 out of 10 remained. Because there is the management want to avert further loss. But as far as the employees are concerned, their services were severed because of redundancy. Now, there is an issue on how much these employees would be receiving. Because if the ground would be redundancy, they would be receiving how much? 1 month pay for every service. But if the ground is to avert serious financial loss, it will only be 1/2 month for every year of service. Now you are tasked to decide on that. Which side are you going to uphold, Justice?
I think, Your Honor, the legal landscape with respect to that questions are really that clear. There are nuances. Sometimes there are decisions saying that because the employer precisely is suffering from losses, that the separation pay is made, say, 10,000 a month or whatever. But sometimes, because the closure of the business is due to redundancy, sometimes the Supreme Court would sustain paying separation pay for a month for every year of service. There are nuances affecting that kind of a situation, Your Honor. That is my view.
So if you are going to decide, which side are going to uphold?
It will depend on, I think, on the audited financial statement that is submitted to the court.
So basically, you would like to prove first if there is really a serial.
The fact of losses, Your Honor.
So if there is really, because obviously because of the pandemic, the occupancy rate of this hotel dropped down significantly for 3 consecutive years. So you would probably give just 1/2 month.
Yes, Your
before
Honor.
this. Yeah.
Depends.
Yeah. So you were teaching remedial law, right?
Yes, Your Honor.
So before, you're no longer teaching.
I had a break.
Yeah, okay. One of the fundamentals of our law is to distinguish substantive law from procedural law. Yeah, and one of the substantive law that we are aware of, no, is the penal laws. No, you mentioned earlier about the criminal laws. So this is the situation, no, and we know that, no, penal laws. No, substantive penal laws can be given retroactive application so long as it is favorable to the accused. So this is the situation. Well, let's say a person, no, was it was, no, during the period of barangay election. So a person was caught, no, with firearms sa kanya, no. So he was charged with violation of the COMELEC's gun ban. But the following day, the law was now took into effect, no, stating that postponing the barangay election. So the accused here moved for the quashal of the information because there is no election to speak of. How can I be legally charged with violation of COMELEC's election ban? There is no election to speak of. No? So question now is, would that COMELEC or law postponing this barangay election be given a retroactive effect? Can it be considered as a substantive penal law?
It could certainly be raised as a defense. But the fact of the matter is, the accused was arrested during the existence when that old law was still effective.
Actually, that was also the way I thought that the Supreme Court would decide on it. But interestingly, it says it can be given a retroactive effect.
Because that is favorable to the accused.
Yeah, and the Supreme Court in that case, no, even mentioned that, no, while this law postponing the election is technically not a penal law, but it can be given, no, a retroactive effect. No? So another question, no, Justice, no. For instance, an accused, no, was convicted in the lower court. And of course, not satisfied with his conviction, he appealed the matter, no, to the appellate court. Can the appellate court increase, no, or modify the penalty, no, such that it would increase the penalty? Napasama pa yung appeal, no? Would it violate yung kanyang right against double jeopardy?
The rule of the matter, the rule, Your Honor, as settled, is that appeal throws wide open the case. So the increase in the penalty would not violate the invocation by the accused of double jeopardy.
It was just posted, I think, yesterday in the Supreme Court website. That was the ruling by Justice Ko. Okay. So what aspect of the SPJI, Justice, do you want to get yourself involved in? And what programs do you want to improve, if not institutionalize?
My understanding, Your Honor, if you prone down at rock bottom the SPJI, it basically would refer to remedial processes and legal ethics. Although the SPGI deals with timeliness, fairness of court decisions, and technologically being technologically adept to pending to the court processes. But at rock bottom really is remedial and legal ethics, because remedial would deal with the processes, which is the focus of the program. You revise the rules on civil procedure to make it more open to the stakeholders, to the parties. That is what the Supreme Court did. You revise, and that is now pending before the court, a proposal also to amend the rules on criminal procedure. There is an administrative matter with respect to electronic filing. That is also covered by the program. And the CIPRA, which deals with the obligation of lawyers to the clients, to the courts, that is also part of the program. Any of those activities I think fit in.
Last question, Justice. So, one of the barometers for global competitiveness is the Rule of Law Index. You're familiar with that, no? So every now and then there are news articles about the Philippines catching up in the Rule of Law Index, no? So adherence to the principles of good governance is one key to improve the country's standing. So the question would be, what would be your concrete plans, particularly involving the principle of equity and inclusiveness, no, to attain this objective or to elevate our standing in this Rule of Law Index?
If you go by the Rule of Law Index and read it hand in hand with the program that is adopted by the Chief Justice now, the SPJI, they are technically the same. It boils down to the same. It will boil down to the same objectives. I would hasten to add that the SPGI is an implementation of that Rule of Law Index.
But is there anything you want to do in order to bolster or let's say to magnify the efforts of the Supreme Court insofar as these principles of equity and inclusiveness?
There is, Your Honor, in the as member of the TWG on CrimPro, we directed the participation of the PDLs. We asked for their views. How could they be, or how their views could be addressed at by the proposed rules? That could probably fall within that context.
Thank you, Justice. That will
Thank
be
you
my
very
last
much.
question.
Thank you, Attorney Firme. Our last interviewer is the Honorable Justice Jose Catral Mendoza.
Thank you very much, Attorney Myra V. Good morning, Justice.
Good morning po.
How are you today?
Well, I am good, but you were not able to listen what I told the panel earlier.
If I heard it, I will not ask any question. But I am the representative, or I represent the retired justices, and they propose some questions. So I'll be asking their questions, and, and some from me later. Oh. I'll begin first with the most senior, Justice Ascuna. Oh. I think you have covered this, but if you want to say something or add more, you can do it. Now, for question number one, in what ways have your present position prepared you to be fit for the Supreme Court?
The Court of Appeals, Your Honor, is the second tired court, the second highest court. We decide cases there collectively. In the same way, that decisions in the highest court are decided by either the division or the bank. Except for some adjustment, I think my length of service, the length of time that I've been in the Court of Appeals, would help if I am appointed to the highest court.
Question number two, what should the Supreme Court be? What should the Supreme Court be doing differently, and why?
It is, I think, Your Honor, it will depend on the situation. The program now being advocated by the Chief Justice, the SPGI, is a good tack that is adopting. It opens the door to the public. It listens to the stakeholders. It revises the rules to be more adept to the challenges of the future.
Okay, the question of Justice Ascuna. The next question was sent by Justice Brion. Is it legally correct to say that our Chief Justice has a more profound influence on law than our President has? Why? Explain fully.
Profound influence, meaning to say that the Chief Justice would in a place higher than the President. I think that is not a good way of looking at it. If you look at the separation of power, look into the principle of separation of powers. Both the executive and the judiciary, or the legislature, in their own respective sphere, are supreme. There are blending powers under the Constitution. The Constitution respects or adopts the blending of powers. So I really could not say, with good reason, that the Chief Justice or the President has a slight edge over the other.
Thank you. The next set of questions come from your kababayan, Justice Tiham. Okay. Number one, would you consider acquitting a person accused of heinous crimes, plunder, human trafficking, and cyber crimes based on procedural grounds? Explain your answer. If the answer is yes, give examples of procedural grounds which you think are reasonable grounds for acquittal.
Say, for example, Your Honor, a person is charged with murder, a capital offense. He was arraigned. Under the rules, the prosecution is directed to present evidence to prove his guilt beyond reasonable doubt and to ascertain the degree of his participation. These are procedural matters. But if, say, the RTC or the court, the trial court, convicts the accused on the basis of that plea, but without asking the prosecution to adduce evidence to prove his guilt beyond reasonable doubt, then because the rules say that his guilt must still be proven beyond reasonable doubt, then I guess a reversal of the trial court's decision will follow.
Second question there is, if the answer is yes, give examples.
Yes, Your Honor.
No, if this is,
uh,
maybe he's asking an actual case.
In fact, even on appeal, a reversal may result if there is an improvident plea and there is that the prosecution failed to adduce evidence to prove the guilt of the accused beyond reasonable doubt and say the charge is murder or rape.
Thank you. Number 2, do you agree with all Supreme Court decisions? Explain your answer. What Supreme Court decisions of recent time do you disagree with vehemently?
There are supposed to be Supreme Court decisions, and I bow my head to whatever the Supreme Court says. But there are, there are Supreme Court decisions which I think have been the subject matter of some criticism. And I am trying to recall.
Sorry. Just one. With which you disagree with.
Yes, Your Honor. I hope I will not be cited in contempt.
It will not be taken against you.
There is this.
Your opinion
There is
will
this
be
Supreme Court
respected.
decision, Your Honor, lately issued by the Supreme Court, restricting the authority of the Court of Appeals when it comes to decisions coming from the SIAC. There was a decision saying, there is now a decision saying that going to the Court of Appeals depends on the matter that the petitioner is espousing. Because before, the vehicle was Rule 43. The decisions of the SIAC goes to us on Rule 43. And you could raise questions of law and fact. But nowadays, you could go only to us on Rule 65 on a limited ground. And all other areas, all other cases will have to go to the Supreme Court on Rule 45. So there is now a curbing of authority from the usual Rule 43 to Rule 65 to us and Rule 43 direct to the Supreme Court. The Supreme Court has changed the legal procedure or the landscape when it comes to appeal from the SIAC. And another thing, Your Honor, is on matters touching decisions coming from the Ombudsman. If it is a case affecting the administrative liability of the petitioner goes to us on Rule 43. But on matters affecting the criminal liability of the petitioner, he goes to the Supreme Court on Rule 65. So there is a Y in the remedies available to the petitioner. My thinking is, could we not just uh, simplify things by, say, giving it altogether to the SC or to the CA.
Anyway, if you reach the Supreme Court, you can maybe suggest that and influence your colleagues.
Suggest, Your Honor.
If you reach the Supreme Court, if
Big
you're
if.
appointed. Number 3, a book author once described the judiciary as the most dangerous branch of government. Do you agree or disagree with that observation? Explain your answer.
Sometimes I agree with that. Although the judiciary does not have the army, the judiciary does not have the money, like the executive or the legislature. But when it inks a decision nullifying a legislative act, then it becomes powerful. When it issues a decision nullifying an act of the president, then it becomes dangerous and powerful.
What is birthright citizenship? Is there birthright citizenship under the Philippine Constitution? In your opinion, is birthright citizenship constitutional or unconstitutional? Explain your answer.
Birthright citizenship refers to the citizenship of the child following the citizenship of his parents, or the principle of sanguinis. That is not clear in the Constitution. But lately, that is an issue now in the states, where the current president would deny birthright citizenship to those born in the states of foreign parents.
In the US, there is a new law which requires, this is now my personal question, a new law which requires a priest to disclose matters heard in confession regarding child abuse. Under our Constitution, is it allowed or not? How about the separation of church and state? Is it a privileged communication? No. You can answer them one by one lang. Kayang-kaya.
If it becomes ecclesiastical, then the wall between the church and the state must be followed. All others, I think, if it is a criminal prosecution, and if the priest is not bound by the confession given to him, since it is a child abuse case, and the universally accepted principle is really to protect children nowadays, then it becomes an open question.
Earlier, you enumerated the elements or the requirements of the control test to determine employer-employee relationship. Aside from the control test, what is the other test?
What, Your Honor?
The other one is control test. You determine employer-employee. There is another test. It's in the case of Amit versus, I forgot, it was, I think, a hospital. What do you call that test?
That test determining also the
Employer-employee.
existence of employer-employee relationship.
Yes.
I think I am concentrated more on the control test.
Yes, so all of us. But The other test is economic reality test. Can you give us just a, may,
Kaya
what
namin,
was the reason of the Supreme Court? But you have not read it.
I would hasten to add your honor on the basis of some labor law principles. Because the
Okay.
relationship between an employee and the employer generally is not balanced.
Yes.
Because of some inequities there, social inequities. Then, a test of that kind may also be used in determining the existence of employer-employee relationship.
The factual milieu there was that the employee had 2 or 3 jobs. And in that case, the Supreme Court used the economic reality test. Anyway, this will be my last question. Death benefits of a seafarer, do they form part of his or her hereditary estate?
I think it does not. It goes to the named beneficiaries of the deceased seafarers.
That is correct. Thank you very much, Justice. That
Maraming
will be all.
salamat. Good. May I
Your
approach the bench, Your Honor?
Thank you, Justice Mendoza. Thank you, Court of Appeals Associate Justice Ramon Cruz. Your Honors, the last candidate to be interviewed this morning is the Honorable Court of Appeals Associate Justice Maria Elisa S. Good morning, Justice.
Good morning.
The first to interview Justice Maria Elisa D. is the Honorable Justice Arlinda Piñera Uy.
Thank you, Attorney Cuevas. Good morning, Justice Sempio D.
Good morning, Your Honor.
You have been with the Court of Appeals for 13 years.
Yes, Your Honor.
What is the majority of cases, nature of cases assigned to you? What field of law does it involve?
Well, I observed that we had a lot of criminal cases, Your Honor, a lot of certiorari petitions, and also labor cases, Your Honor.
Have you encountered cases wherein the issues do not have clear legal precedent?
Sometimes, Your Honor, yes.
So how do you go about it?
Well, we really do a lot of research, Your Honor, to get cases, sometimes even U.S. cases, if there is really no jurisprudence locally, Your Honor.
Can you describe in general, your work ethics?
Well, when I joined the judiciary, Your Honor, I got to love this branch of government. And I started from the ranks, down the ranks, MTC, RTC, CA. And I've learned to love the institution, Your Honor. So it's out of love and passion that I work, Your Honor. It's not just for the pay, and not for the perks, but for the love, Your Honor.
When you were with the RTC, was your court a court of general jurisdiction or special court?
When I was in the RTC, Your Honor, for almost 7 years, I was family court, Your Honor.
Family court.
And then during the last few months, I think, I became regular already.
I see. In your PDS, it stated that you voluntarily inhibited by motion in 3 cases. Is this with are these cases with the CA or previous cases with the RTC?
I believe, Your Honor, in the Court of Appeals.
I see.
Yes, Your
And
Honor.
how what would be the grounds
I think one was because the party was the godfather of my brother in his wedding. One was, I think, one party, the petition for nullity of marriage filed with the RTC, with my court at the time, family court. I was the one who ruled on it. That is why I had to inhibit here when a matter was raised here, Your Honor. I mean, in the Court of Appeals.
Please correct me if I'm wrong. In your PDS, it appears that as regards to cases undecided or unresolved within the reglementary period, there are 124 cases?
Because, Your Honor, that was during the 5-year period when there was the pandemic. And we were given very limited time to work on cases, even if there were quarantine orders or instructions. So the deadlines had to be moved for the periodic period. But those are very minimal movements, Your Honor, since we just had to cope with the time that we had to be here in the court, I mean the office.
Did you ask for extension of time to resolve the cases?
At that time, no, Your Honor, because we were given the period anyway. So we just did our best to come up with the decisions.
And what's the status of these unresolved cases? How many are
I think all of them had been
all
resolved
resolved
already. Yes, Your Honor.
already? What do you think are the qualities that are essential for a Supreme Court justice, and how do you embody these qualities?
Your Honor, I've always believed that a Supreme Court justice has to develop a certain judicial maturity, judicial temperament that is worthy for the highest court of the land. I believe when I was younger, I was still harnessing such judicial maturity. And I would like to believe, Your Honor, that I've reached the point.
Have you been assigned any high-profile or celebrated case or cases? And please share your experience in handling this case or cases.
Well, the ones that I remember when I was appointed in the Court of Appeals was first regarding the power of the MMDA in arresting individuals for smoking, I think, smoking at that time. And we had to rule that police power, that the MMDA did not have such police power, Your Honor, that time. Now, there are other cases on ombudsman matters, Your Honor. So I think they're still high profile since these cases involve politicians, Your Honor, from LGUs.
What happened to the MMDA case? Was it appealed?
I have no idea, Your Honor.
You don't know
when-
what happened?
I wasn't updated anymore after we released the decision.
You mentioned that in the ombudsman cases, it involved politicians. Have you experienced any political or external pressure in relation with this case?
Well, thankfully,
Nobody
there was-
approached you?
No, Your Honor. We just had to deliberate a lot regarding these cases so that we can apply the proper jurisprudence on the issues.
In the Court of Appeals, have you encountered a situation wherein you disagreed with a colleague on a legal issue, and how did you handle the disagreement?
Actually, Your Honor, I have not in my 13 years dissented. But during the deliberations, I give my opinion, especially when I became chair, Your Honor, because I felt I had more responsibility to really analyze and scrutinize the decisions of my members, Your Honor.
So how did you handle a disagreement? Like, did you present it in written form, or you just discussed it during deliberations?
Well, the first step, Your Honor, for us is to discuss verbally. But there was also a time when I would make some sort of a letter, put jurisprudence there, addressed to the members, Your Honor, particularly the ponente, Your Honor.
How about a situation where a colleague on the bench acts unethically, such as influencing you to act in favor of a specific party?
Well, I have not really experienced that kind of actuations, Your Honor.
You have not been approached by any colleague
Well,
regarding a specific case?
not regarding specific cases, Your Honor. Maybe we just discuss on particular issues, if especially if the issues are difficult. So I remember that when I was a junior, that there would be some sort of mentoring for us juniors, Your Honor.
If appointed to the Supreme Court, what significant experiences or achievements will you be bringing with you to the highest court of the land?
All right, Your Honor, other than the fact that I am now 11th Division Chairperson in the Court of Appeals, I'm a proud graduate of the academic courses on the Hague Academy of International Law that was conducted in Philja, Tagaytay. And in result, I became the head of the Philippine delegation who went to the Hague, Your Honor, for possible accession to certain treaties. And eventually, I heard that we were able to accede to the 1970 Evidence Convention, Your Honor, of the Hague Conference on Private International Law.
Is this your first time to apply
For the Supreme Court,
for
Your
the
Honor.
Supreme Court?
Second time, Your Honor.
So the other time was when we interviewed you was for presiding justice.
Yes, Your Honor.
If appointed to the Supreme Court, how will you approach constitutional interpretation? Will you follow, there are several theories,
For constitutional interpretation.
textualism, it emphasizes the plain meaning of the constitutional text. Or if it's originalism, it focuses on the original meaning of the constitutional text. And then the living constitution is that our constitution is dynamic document. Which of the three would
All
you
right.
follow?
I think it would be some sort of a three-step approach, Your Honor. So the first step would be to look at the verba legis, or the wording, the exact wording of the Constitution. However, if the circumstances call for certain application of contemporary interpretation, then to be able to have a living constitution that will adapt to the progressive times, then I believe I will have to be more liberal on those issues, Your Honor.
So you would be willing to adopt any of the theories depending on the specific circumstance of a case.
Yes, Your Honor.
I see. You were once a family court judge. What is the essence of the unavailable child doctrine in cases involving child abuse?
I remember, Your Honor, this doctrine came from the rule on examination of a child witness, because there are certain situations where a child, the private complainant, for example, in a sexual assault case, may not be available to testify in court against the perpetrator.
The private complainant would be a child.
Yes, Your Honor, the
Yes.
private
So
complainant.
what's this doctrine all about?
So this doctrine allows out-of-court statements on the part of the child to be admitted in evidence as an exception to the hearsay rule. Because as the Supreme Court expounded in certain jurisprudence, the child may be sick, for example, sick, lack of memory, infirm, or because of psychological stress in, let's say, seeing the perpetrator in the flesh. And as long as such statements of the child out of court are corroborated, Your Honor, by another witness, then such evidence may be admitted and may even cause the conviction of the accused.
And you agree with this ruling?
Yes, Your Honor, I do.
What is the legal remedy for a person who has been wrongfully deprived of liberty due to mistaken identity?
Mistaken identity. So if that person has been deprived of liberty, then habeas corpus, a writ of habeas corpus may be issued to be able to check the legality of the detention, Your Honor. And that would be the time that the matter of mistaken identity may be threshed out.
Have you handled environmental cases?
Not really, Your Honor. I was a junior before a long time ago, during the time when my chair was Justice Carandang, but I was not the ponente then, Your Honor.
What was the issue involved?
It's been a long time, Your Honor. But I think it has something to do with water, or certain poisonous or toxic substance in a certain area, Your Honor.
In Metro Manila?
I think so, yes.
Do you remember how it was resolved?
No, Your Honor, I'm sorry.
Are
It's
you
been a long
familiar with the
time.
rules of procedure for environmental cases?
I have an idea, Your Honor.
Would you know the consent decree
Consent decree.
issued in relation to environmental cases?
When certain parties consent to a document in order to protect the environment.
Okay, try harder. It's a consent decree. Does it involve participation of the court?
No.
It's a decree, remember?
Yes. But it will be approved by the court, Your Honor.
Yes.
So the parties will come up with such agreement and submit the same to the court.
Yes. So that's my last question. Good luck to you, Justice Tempudi.
Thank you so much, Your Honor.
Thank you, Justice Uy. Our next interviewers, the Honorable Attorney Nasauro H. Firme.
Thank you, Attorney Cuevas. Good morning, Justice.
Good morning, Your Honor.
So how did you prepare for today's interview?
I had a good breakfast with tocino, Your Honor,
Okay.
and achara.
That must be the lucky charm for you. Okay, I have two sets of questions. One comes from the Secretary of Justice, and of course, the other mine will be my own set of questions. I'll read the question of the Secretary first.
Yes, Your Honor.
So number one, you were part of the Philippine delegation to the Hague Conference on Private International Law in 2024. How was your exposure to international law influence your interpretation of domestic laws, particularly in cases involving international agreements and human rights?
Well, first of all, Your Honor, when we went to Hague with the delegation, we were exposed to all the possible treaties that we can accede to. So at that time, we were still considering acceding to the 1970 Evidence Convention and the Judgments Convention. Now, as I mentioned to Justice Uy, Your Honor, effective July 5, I think, 2025, July 5, sometime that area, we will have the evidence convention applicable to our country since we are now acceding as a state, so it becomes easier, Your Honor. The way I look at it, when we connect it to domestic law, it becomes easier for Filipinos to gain justice when there is an international element or a cross-border situation, Your Honor. Since as of this time, we already have 6 conventions that we have acceded to, Your Honor. Support, child abduction, service apostille, um, something like that. Evidence, and one more, Your Honor. That missed.
So the next question would be, your background indicates extensive academic experience, having taught constitutional law, political law, and legal philosophy at various law schools. Given your theoretical expertise, how do you ensure that your judicial decisions are grounded not only in legal principles, but also in practical realities?
I have always believed, Your Honor, that when I decide a case, I base it on law, no constitution, the laws of the land. However, since times are changing, Your Honor, and there are so many progressive changes on technology, on lifestyle, on the needs of the Filipino people, then there may be certain tweaks, Your Honor, that we should do. And that I actually believe in certain ideas of what we call judicial activism, Your Honor, on the part of the Supreme Court to be able to adapt to these changes, Your Honor, the contemporary needs of our people.
Your work on judicial dispute resolution, or JDR, emphasizes alternative dispute resolution methods. Do you believe that the Supreme Court should institutionalize JDR at all levels of the judiciary, including the appellate level? Why or why not?
Personally, Your Honor, I believe mediation does the job already. I don't think there is a need for JDR, let's say in the appellate level, because that might take time, Your Honor, because there's already the PMC that may be applicable. Now, as to the lower court, Your Honor, that's a different situation because there we deal with the litigants themselves. We see them physically, and hence there is a certain connection between the judge and the litigants, Your Honor.
Okay, the fourth question would be, as a member of the technical working group on pleading, practice, and procedure, you have contributed to procedural reforms. In your opinion, what is the most urgent procedural reform that the Supreme Court should prioritize and why?
First of all, Your Honor, the draft that we made was still submitted to the Supreme Court for approval. But from what I remember, the most important emphasis of the changes that we discussed or put into the rules would be to prevent delay, Your Honor. So for example, if it's an appeal, if it's petition for review, there are 3 steps. But if there's a one-step procedure, then the time element would be material, Your Honor, materially reduced. So I think that would help a lot in giving justice faster, Your Honor, to our people.
It can be said that our Constitution share some similarities with the U.S. Constitution. As hopeful to become a final arbiter of constitutional issues, can you pinpoint to us one particular constitutional principle that you will strictly guard against being influenced by U.S. jurisprudence, albeit similarities in our constitutions?
Maybe freedom of expression, Your Honor, and due process situations. Although there are similar provisions in the U.S. Constitution. For example, in the U.S. Constitution, life, liberty, and the pursuit of happiness. So the pursuit of happiness, quote unquote, is quite it's a big idea, Your Honor. In our country, life, liberty, and property. So somehow it has been, the parameters had been limited, Your Honor, and I believe in that, Your Honor, so that there will also be no abuses as to due process rights, Your Honor.
Sixth question, with your long years of practice of law and now as an applicant for the Supreme Court Justice position, can you share to us your judicial philosophy?
I believe, Your Honor, that positive law should not be altogether different from divine law based on the law given to us by God. Although, of course, there are different religions and different beliefs, then positive law should still be hinged on divine law, Your Honor. That is what I believe.
So do you have a particular justice here or elsewhere whom you consider an idol and why?
Other than Justice Mendoza, Your Honor. Does the justice have to be an incumbent?
Well, it did not say, probably a retired one or probably someone who have passed away.
Well, Justice Mendoza has been in the Quezon City before as EJ and RTC, and I've known him for a long time, and I idolize him, Your Honor.
The more important question would be why?
I think I would connect that to my legal philosophy, Your Honor, because I know that he's very close to God, Your Honor. He's a God-fearing magistrate. Even before when we used to attend retreats.
So the next question, assuming you were appointed to the Supreme Court and given the long number of years that you will be there, what do you wish to contribute thereto and to the whole judiciary aside from decision making?
Your Honor, I really admire the SPJI program of our Chief Justice because with the efficiency, innovation, and access elements of the SPJI, the court is trying to move the judiciary closer to the people, not just some institution up there on an ivory tower, but something that is part of the lives of the ordinary person. For example, the magtataho, Your Honor. Then he would understand access to justice, the innovations, for example, the Facebook page where there are podcasts that he can listen to and read the summary of the decisions in Filipino. That would be very good ideas, Your Honor, to explore and to develop when, if I'm given the blessing, Your Honor, to be in the Supreme Court.
So in the context of criminal law, how do you reconcile the principle nullum crimen sine lege or no crime without law with the rapidly evolving nature of crimes in the digital age, such as cybercrimes and artificial intelligence-assisted offenses? As an indispensable pillar of criminal justice system, how could the Supreme Court address the matter?
I think the best example of such situation, Your Honor, where a certain law, a certain felony, for example, libel in the RPC, it is given a certain mode to cover cyber libel situations. Because as I mentioned, before, when the RPC was framed, we did not really imagine such situation that there would be email or internet libel or something that comes out from the web. So cyber libel as a certain form of libel is a good example of addressing the situation where there is no law punishing a certain act. So now there is, Your Honor.
The last question would be, the principle of proportionality requires that the punishment must fit the crime. How do you view the constitutionality of mandatory minimum sentences which limit judicial discretion? Should the judiciary have the authority to invalidate such laws if they lead to unjust results?
Your Honor, just to clarify, so we are referring to the minimum of a sentence. I believe, Your Honor, that the fixing of the minimum and the maximum of a sentence is very important because that will give the accused or the detained, the prisoner, or the perpetrator or a criminal certain leeway to be able to reach the minimum because of good behavior, Your Honor. So good behavior can cause the application of the minimum, and that person will have hope for change for a second chance.
So this will be my questions, actually from the academe also. They sent me some questions. So in AM number RTJ 10-2248, September 29, 2010, you were admonished to be more circumspect in observing the reglementary period for disposing of motions. Since then, what adjustments have you made, and what have you learned from that decision or admonition?
I've learned a lot, Your Honor. I always come up with my tickler, a record. I do not rely on the staff for this because that was my mistake at that time. I relied on the clerk. So now I have my own. I have a list of what will be due and what cases should I prioritize at the moment, Your Honor.
So I noticed, Justice, you worked with the NAPOCOR, correct? Yeah. So you can easily answer this one. No? In fact, this was asked in the recent bar examination. So this is how it goes. No? The NAPOCOR, through its board, allowed the granting of some allowances. However, the COA issued a notice of disallowance saying that before these allowances could be issued or given to the employees, there must be a president's approval, the president of the Philippines. No? Now, the board says, one of our members here in the board is the Secretary of Budget. And therefore, under the alter ego doctrine or the qualified political agency, no, there is no need for the approval of the president because if the Secretary of Budget approves it, it is as if it has been approved by the president. Now it has reached the office of Justice of the Supreme Court, Maria Elisa D. How are you going to rule on that? Would the doctrine of qualified political agency apply to that case?
Just to clarify, Your Honor, the facts would refer to NAPOCOR during the time when it was not yet owned by private individuals, right?
But even it's still now, no, there is one of the members that sit there is the Secretary of DBM. No?
I think the doctrine of qualified political agency will not apply, Your Honor, because the COA has the duty to check the expenses, Your Honor. It is a sworn duty being an independent constitutional commission, Your Honor.
Eh, nakalagay doon, di ba? The ex officio siya sitting there as an ex officio officer. Just like in us, no, in the JBC. The Secretary of Justice is an ex officio member of the JBC. So is there a need for the President's approval, even the Secretary of Budget sits there as an ex officio member of the board?
I think the approval will still be needed, Your Honor, because the Constitutional Commission has done its job already, and it's a matter between the President and the COA, Your Honor.
Well, the answer is correct, no? But the Supreme Court said that when we speak of ex officio, it means that he is placed there not in a capacity or a representative of the President, but because of the office. So there is no alter ego doctrine in that case. No? So you were also teaching constitutional law, and your idol is Justice Mendoza. So what is the benevolent neutrality in constitutional law? You were still there in the Quezon City at that time about the holding of masses? Or you were not?
Holding of masses in the court
Yeah,
during the
ano ba yung ground floor?
noontime masses, Your Honor.
At the basement?
Yes.
You were there.
Yes, I
So the one who penned the decision is Justice Mendoza. Made mention of this benevolent neutrality, a concept in constitutional law.
I think it's a concept on the freedom of religion, Your Honor. Because there are many cases where we apply benevolent neutrality and strict neutrality, where the state, when it's strict neutrality, there is a certain separation of church and state, no? Which is one of the doctrines in our Constitution, that is applied strictly, meaning no exceptions. But when you say benevolent neutrality and the certain acts of individuals are not really malicious or detrimental to society or to the court in that situation, the RTC, then it may be allowed, Your Honor, the exercise of freedom of religion.
I was asking Justice Mendoza if your answer is correct. Another question is about constitutionalism, since you are teaching that subject. Have you read or come across with the case of Cruz versus Sagani Cruz versus Secretary of Environment and Natural Resources? It's very interesting because of the 7-7 vote in the constitutionality of the IPRA. Have you come across that?
Vaguely, Your Honor.
So-
IPRA.
So the petitioners here question the validity, constitutionality of IPRA because, according to them, it violates the Regalian Doctrine. How? Because under the IPRA, it says that the natural resources found in these native lands, ancestral lands, can be utilized, developed, and exploited by the IPs. So sabi nila, it's violative of the Regalian Doctrine because under the Constitution, it says that the natural resources shall be under the control and supervision of the state. And it cannot be given to the IPs. So it's a close voting. 7-7. Meaning to say, the law has not been declared unconstitutional because of failure to muster the required number of votes to declare it unconstitutional. So now, you are the Justice of the Supreme Court, assuming it is still pending. Which side are you going to take? Would you take the Regalian Doctrine, meaning to say it is the state who is the owner of this property? Or are you going to take the sides of the IPs saying that they have been given that right over these lands, native lands, since they have been there since time immemorial. So that was basically the issue in that case.
Your Honor, the more conservative view would be to apply the Regalian Doctrine because, of course, the property belongs to the state. However, thinking about the needs, the history, all the observations of struggles of indigenous people, then I would take the liberal approach, Your Honor, and grant them certain rights to their lands that they have been occupying for the longest time, so many years, Your Honor.
So you also mentioned that you've been had significant understanding of our international laws because of your involvement in the Hague Conference on Private International Law. Yeah. So what is your understanding of the doctrine of incorporation?
All right, the doctrine of incorporation, based on our Constitution, is that international law is part of the law of the land. So if there is some sort of conflict between a local law and the international law, then we consider also the provisions of, for example, the Universal Declaration of Human Rights. However, there is an exception, for example, the police power, where it is asserted that a local law may still prevail over an international law principle because of police power, Your Honor.
So do you think the Philippines is a monist or a dualist? It's about the relation of the local laws and international laws.
I think it's we're more of a dualist
Dualist.
society since we consider international as part of the law of the land, Your Honor.
As we say, as you mentioned, Justice, no, that it takes part of the law of the land. So, does it somehow trivialize the judicial power to rule on the illegality of these treaties, international agreements? In fact, in several cases decided by the Supreme Court, no, it says that this international law, no, would apply here even there is no local legislative action. No? And in other case, it says that it is absolute and all-encompassing in domestic level. So technically, it becomes part of the law of the land. And would it trivialize our power of judicial review?
Well, Your Honor, from my experience, the ones that we have acceded to in The Hague, for example, the conventions, all pass through the Supreme Court. In fact, certain rules, I remember already the 6th convention, the Service Convention. There are certain rules, Your Honor, that are promulgated first by the Supreme Court to be able to adapt to certain situations whenever there is already an accession to a treaty. So I believe that the Supreme Court is still there as the guardian of the Constitution in case such treaty is violative of our Constitution and our laws, Your Honor.
So I heard earlier also, Justice, you're teaching, or you came across with environmental law. It's very recent, if I heard it right.
I was a junior, Your Honor, during that
You're still a
time.
junior looking. Okay. The question is, so what is your understanding of the precautionary principle and how would it affect your decision in the issuance of writ of kalikasan?
Well, the precautionary principle applies, Your Honor, when there is the absence of a law on a certain situation that affects the environment or that affects the people's right to a balanced and healthful ecology. Now, even if there is no law applicable in that situation, the Supreme Court can apply the precautionary principle to prevent such damage to the environment.
So how would it affect your decision, no, if ever you are to issue a writ of kalikasan?
I can use it as my basis, Your Honor, for the issuance of a writ of kalikasan to protect the people from certain damage.
Justice, you were reported to be conducting a workshop seminar with the Presidential Legislative Liaison Office where you discussed the proposed divorce bill. Were you part of that? So
I was invited, Your
Yes.
Honor, to
make a talk.
have us maybe make a lecture or do a lecture on moving on for
Yes.
God, Your Honor, because some of them are
But not
broken-hearted.
necessarily divorce
Not
bill.
necessarily the divorce law at that time. I just discussed Tan Andal versus Andal.
So what is your stand on divorce bill?
Well, Your Honor, I always look at Article 36 as good law, notwithstanding any divorce bill, because Article 36 is true to our beliefs as the Filipino people on the institution of marriage. Because if you look at psychological incapacity and look at all the jurisprudence on the matter, it is as if there is no marriage, Your Honor, no bond to break. In divorce, when we talk about divorce in the United States, we are breaking a bond. And we're not doing this here, Your Honor, because we respect the bond of marriage.
So I would assume your expertise in family law would now become apparent. I'll ask you a question. It actually been thinking this question for quite a long time. This is about the presumptive death. Diba? If a spouse is missing, no, the present spouse can declare the missing spouse, no, presumptively dead for purposes of contracting second marriage, no. And this second marriage can only be invalidated if there will be an affidavit of disappearance on the part of the missing spouse. So the question now is, and I will take advantage of your presence here, what if this missing spouse did not file an affidavit of reappearance? Can he contract a marriage?
We're just to clarify, Your Honor, we're referring to the one who was left. For example,
The one who was declared presumptively dead. Because, diba, sabi natin, the second marriage contracted by the present spouse will only be invalidated if there is an affidavit of reappearance. But what the missing spouse did, no, he did not file any. At instead, contracted a marriage.
so the one who contracted the marriage was the absentee spouse? Oh.
There is no provision of law.
Yes,
about
there
that.
is a void in the law on that matter, Your Honor. But in that case, if that person even had the gall to physically appear in a ceremony, then he's not absent, Your Honor. He's present very much.
But they said, no, dapat merong affidavit of reappearance. But for purposes of the records, he is presumed to be dead. O nagpakasal before Justice of the Supreme Court, Myra Elisa D. And you were not aware of the the declaration that he was presumptively, no, presumed to be dead.
Just to clarify, Your Honor, so that means I already know also of the second marriage, the marriage that he contracted. Do I know that?
You were the one who officiated the second marriage. The marriage of the missing spouse. Before your office, you were
So I was the
you
one who-
just took your oath. And then there is this friend of yours. Can you celebrate or officiate this marriage? He said, yes. You will be the first marriage I will celebrate.
So the question is, Your Honor, if I would still consider this person
What is the
presumptively
status of this marriage contracted by this missing spouse?
I still believe that it's void, Your Honor. It's a bigamous marriage.
Would it not be unfair? Because remember, the present spouse was able to contract a marriage.
So the present spouse already contracted a marriage.
Kaya that's the reason why the present spouse filed an affidavit of disappearance, presumed because of the presumption that he's dead, in order to contract a second marriage.
Well, there is also a doctrine, Your Honor, that the party cannot declare his own marriage as void. He needs a declaration from the court, Your Honor.
So that marriage you celebrated is valid.
At that point, Your Honor, where I did not really know that this person is the same absentee spouse, then at that point, it was valid.
Sige, the last question, Justice, you're giving hopes to others. Okay. The last question would be, so one of the barometers for global competitiveness is the Rule of Law Index. You're familiar with that? No, so the Philippines has been trying to improve its standing in the Rule of Law Index for, of course, global competitiveness. So adherence to the principles of good governance is one key to improve our standing. So now, as a potential justice of the Supreme Court, what would be your concrete plans, which particularly involving the principle of efficiency and effectiveness, no, in order to attain this objective?
I would be fully supportive of the programs on case flow management, Your Honor, for efficiency. And also, I remember that I read somewhere in the Rule of Law Index regarding the corruption level, then to take steps to improve such level, Your Honor.
So what are the concrete plans regarding this corruption and the efficiency? The court management thing that you mentioned earlier.
I think our present Supreme Court is already doing it with the CIPRA, Your Honor, the caravans. There is an emphasis on all the elements of the CIPRA to imbibe or inculcate such values upon our judges, Your Honor.
Thank you, Justice.
Thank you so much, Your Honor.
Thank you, Attorney Firme. Our last interviewer is the Honorable Justice Jose Catral Mendoza.
Thank you very much, Tony Marife. Good morning, Justice.
Good morning, Your Honor.
Because of one of your answers, I would have been inhibited from. Anyway, I represent the retired Supreme Court justices, and some of them have suggested questions. I will read first the question of the most senior Justice Ascuna. Number one, in what ways have your present position prepared you to be fit for the Supreme Court? Okay. You answered that earlier, but you can elaborate if you want.
All right, Your Honor. When I reached the point where I became chairperson, then there is a certain development of temperament and maturity that a chairperson has to possess. Because certain, of course, the senior member, the junior member, I feel responsible for the division as regards our disposals, as regards the correctness of all the decisions that we promulgate. So such attitude, Your Honor, is something that a Supreme Court justice must have. And another thing would be, as I mentioned also, would be the courses that I took at the Philja Academy on Hague International Law, Your Honor.
Question number 2, what should the Supreme Court be doing differently and why?
Differently. I believe in everything that they do now because I said, as I mentioned, Your Honor, they are putting the court nearer the people. And there is greater access, Your Honor, especially when we look at social media. We have Twitter, X, and the Facebook page, Your Honor. Then the individuals or the litigants or the common person will understand better the decisions of the Supreme Court.
Thank you. The next question came from Justice Brion. Is it legally correct to say that our Chief Justice has a more profound influence on law than our President has? Why, and explain fully.
Just to clarify, Your Honor, our Chief Justice compared to our President?
Yes, I'll repeat the question. Is it legally correct to say that our Chief Justice has a more profound influence on law than our President has?
I think that would be an inaccurate statement, Your Honor. Not really precise in a sense that profound influence is not dependent on the position of the Chief Justice.
Okay, that was the one and only question of Justice Brion. He promised to send more questions, but he missed the deadline.
Lucky for you.
The next set of questions comes from Justice Tiham. Question number 1, would you consider acquitting a person accused of heinous crimes, plunder, human trafficking, and cybercrimes based on procedural grounds? Explain your answer. If the answer is yes, give examples of procedural grounds which you think are reasonable grounds for acquittal.
Yes, Your Honor. A procedural ground would be a valid ground for acquittal. For example, if a certain piece of evidence had been admitted by the court when it should not have admitted such piece of evidence based on our rules of evidence, then it may be used as a ground for acquittal. It can be the cause or basis for reasonable doubt, Your Honor, no matter what the crime is.
Okay. Question number 2, do you agree with all Supreme Court decisions? Explain your answer. What Supreme Court decisions of recent time do you disagree with vehemently?
Vehemently, Your Honor. Well, with due respect, there is one decision that I believe in the result. I understand why the Supreme Court promulgated such decision, and it is Republic versus Manalo regarding the second paragraph of Article 26 of the Family Code. Because in that decision, Your Honor, penned by the Chief Justice Dado Peralta, the alien spouse mentioned there in that provision, the term was made to apply to a Filipino who went abroad and got naturalized. But I believe in, Your Honor, I had the privilege to know the intent of the framers with due respect, in the discussions during the minutes of deliberations would be that the framers were really referring to a foreign and alien spouse. However, as I mentioned, I believe in the result, Your Honor, because there would be an absurd situation, but not really vehemently, Your Honor. Because there would be an absurd situation, Your Honor, when the Filipina or Filipino spouse here is left without a husband or a wife anymore because that particular person who got naturalized abroad was able to get a valid divorce.
Okay, I will just interject a question. What do you call that? Judicial legislation or judicial activism?
I think it falls under the term judicial activism, Your Honor. Because in that case, the Supreme Court interpreted the word alien spouse in relation to the first paragraph, which refers to a foreigner. Now, the Supreme Court did not add anything to the law, but only interpreted the coverage of the term.
Okay, another point related. How about, I'm sure you know this, you know the Iron Curtain rule in succession. Aquino versus Aquino, that was. What is that? What is your opinion? Is that judicial activism or judicial legislation?
Once again, Your Honor, I believe that when Justice Marvick Leonen penned the decision, it was judicial activism because somehow it cured the image of quote-unquote the illegitimate child, and he named the child non-marital child instead. And regarding the matter of succession, there was a prohibition under the rules of succession, the laws on succession, stating that the non-marital child cannot inherit from legitimate ascendants, descendants, and collateral relatives of the father or the mother. So according to Justice Leonen, there's some kind of hostility created by such provision. So another provision was applied, I think Article 992 regarding the
982.
regarding the inheritance, whether or not the child is illegitimate or whether the child is legitimate. And he also changed the terms, the lexical terms into non-marital and marital child because of course some children, they have no hand on the matter of being an illegitimate child. For example, maybe a child of a victim of a sexual assault, or two people that did not marry, Your Honor, despite lack of impediment.
Yes, thank you. Question number 3. A book author once described the judiciary as the most dangerous branch of government. Do you agree or disagree with that observation?
I think that book author has a point, Your Honor, because the judiciary has the power of the pen, the power of writing, the words. The words have power, Your Honor, when they are read and understood by readers, Your Honor.
Thank you. This is question number 4. If you know only, in the U.S. Supreme Court, there are 9 justices. Who is considered as the 10th justice?
the 10th Justice, Your Honor.
Yeah.
But
It's
there are
all
only
right
9.
If you do not know, it's all right. I'll go to the next question. You can easily answer this. You teach constitutional law. What is birthright citizenship? Is there birthright citizenship under the Philippine Constitution? In your opinion, is birthright citizenship constitutional or unconstitutional? Explain your answer.
Birthright. By blood, Your Honor, if it's birthright. So the question is, is it constitutional or not?
Yes, under our Constitution.
Yes, Your Honor, because, for example, a child of a Filipino parent is considered Filipino, Your Honor.
Wala. Oo. It's another question from Justice Tiam again. If you only know, what is the doctrine of Rule of Four adopted in the U.S. Supreme Court? Only if you know.
Rule of 4?
Yes, adopted in the U.S. Supreme Court.
I'm sorry, Your Honor, Rule of 4.
Okay lang. Sa US naman yun eh.
Okay, Your Honor.
Okay, you teach constitutional law. No?
I used to teach it, Your Honor, but I no longer teach right now, Your Honor. It became difficult when I became chair, Your Honor.
Oh, I know that at least you know this. What are the 3 inherent powers of the state? Very easy.
Police
for you.
power, eminent domain, and taxation, Your Honor.
Okay. My question really is the Senior Citizens Act. What is it? What is its basis? Taxation, eminent domain, or police power?
Actually, the main foundation of the Senior Citizen Act is police power, because it protects the welfare of senior citizens. However, there are situations, Your Honor, where eminent domain as an implement of police power may be used for senior citizens. For example, that there is a black screening of a movie for them only. Something like that, Your Honor.
Compensation there, eminent domain. Is there compensation?
If it's an implement of police power, Your Honor, there is, it is just the good feeling, Your Honor.
Yeah, no, you answered.
There is no monetary
Yes,
compensation.
Yes. Your answer, police power, is correct. The Supreme Court agrees with you. The case of Carlos Superdrug. But you mentioned eminent domain later. So I'm asking you, is there compensation involved when you mention eminent domain?
I think the only compensation is the altruistic feeling on the part of certain owners, Your Honor, that give benefit to senior citizens.
Okay. You mentioned earlier that positive law is hinged on divine law. Is it not, or is divine law the same as natural law?
No, Your Honor. Natural law is the inherent law of things in the universe. Divine law would be something, for example, the Ten Commandments, the Quran. Those are examples of manifestations of divine law.
They're not covered by natural law? you're speaking only of the physical structure, or because natural law is also recognized under our laws. Yes.
It can also be the foundation, Your Honor, of certain laws. But natural law and divine law are different, Your Honor, in their jural foundations.
Yes. Where in our set of laws, natural law is mentioned.
The law on natural resources, Your Honor, is a good example of laws where natural law or the law on physical things, the inherent state of things, could be
With the-
applied.
with, because of the enactment on the laws of natural resources, they became positive law kasi written na. How about natural law itself? Natural law. Quote, natural law, unquote. Is there a provision under our laws?
Maybe, I think, laws on science, Your Honor, on DOST, science and technology, because sometimes they, of course, base their laws on physics, Your Honor. For example, physics, chemistry.
Natural law is mentioned.
I'm not sure, Your Honor, if the word natural is mentioned.
Natural law is mentioned in Article 1423 of the Civil Code. Anyway, do not teach that. You mentioned earlier cyber libel. Do you know the prescriptive period for cyber libel?
Your Honor, since cyber libel is considered a mode of libel per se, libel, the prescriptive period for libel is 1 year, Your Honor.
Correct. Oh, they abandoned the older doctrine, which ruled that it prescribes in 15 years. Okay. In the United States, they passed a law which requires priests to report confessions regarding sexual abuse or abuse of minors. In the context of the Philippine Constitution, what is your view?
I think that would fall under the separation of church and state,
Churches.
Your Honor, since the seal of confession is one of the most solid seals of the Catholic Church, Your Honor.
Is it a privileged communication?
It would fall under that, I believe, Your Honor. Although I have personal reservations since sexual abuse is involved. So maybe we can come up with our own, because as you mentioned, Your Honor, this is United States, no?
In the United States.
That the Philippines will come up with certain exceptions to the seal of confession.
Would not be that be violative of the constitutional provision on the separation of church and state?
It's a matter of looking at the hierarchy of values, Your Honor. What is number one there? Is it religion, the exercise thereof, or protection of individuals from crime?
In labor, one of the tests to determine employer-employee relationship is the control test. What is the other test?
The right to hire the person, the right to dismiss the person,
No, no. What do you call that other test? Because that is already covered by the control test, what you mentioned. Those are the elements of the control test. If euro only, okay lang.
Your Honor, the right to put all the qualifications for for employment.
That falls under the control test. Anyway, it's the economic reality test. It's mentioned in the case of Amit versus Cagayan de Oro Clinic. That will be all, Justice. Thank you very much.
Thank you so much, Your Honor. Thank you for
you're
this
ex-
privilege
you're
you've given me.
excused.
Thank you.
Excuse na.
Thank you, Justice Mendoza. And thank you, Justice MPD. Good luck po. Good afternoon, Your Honors. We will now resume the public panel interview of the candidates for the position of Supreme Court Associate Justice, Vice Honorable Myra V. Lopez. Present in this afternoon's public panel interview are the Honorable Justice Jose Catral Mendoza, JBC Executive Committee Chairperson and regular member representing the retired justices of the Supreme Court. Honorable Attorney Nesauro H. Firme, regular member representing the Academe. And Honorable Justice Erlinda Piñera Uy, regular member representing the Integrated Bar of the Philippines. Your Honors, the candidates to be interviewed this afternoon are Honorable Court of Appeals Associate Justice Myra V. GARCIA-FERNANDEZ and Honorable Court of Appeals Presiding Justice Fernanda LAMPAS Peralta. May we request Your Honors to please stand up and raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth in this public panel interview of the JBC? So help you God. Thank you. May we request Justice Fernandez to please take your seat in the middle, and Presiding Justice Peralta to please proceed first to the holding area. Good afternoon, Justice Fernandez.
Good afternoon.
Your Honors, the first candidate to be interviewed this afternoon is the Honorable Court of Appeals Associate Justice Myra V. GARCIA-FERNANDEZ. The first to interview Justice Fernandez is the Honorable Justice Erlinda Piñera Uy.
Thank you, Attorney Cuevas. Good afternoon, Justice Fernandez.
Good afternoon, Justice.
I have two sets of questions. The first set are questions from the Secretary of Justice, and then to be followed by my own set of questions. Question number one, you have participated in international training, including a summer course in public international law at the Hague Academy. How has your exposure to international law influenced your approach to domestic legal issues, especially those involving international treaties and human rights?
I am privileged to have been sent by the Supreme Court on official business to the Hague Academy. And upon my return, I submitted my report on the training to the Supreme Court at the time through Chief Justice Reynato Puno. At the time, I was still a judge of the Regional Trial Court of Manila, handling heinous crimes cases. So my training helped me a lot in being aware of the treaties and international covenants entered into by the Philippines with other states. Example would be the International Covenant on Civil and Political Rights, as well as Universal Declaration of Human Rights. So when I was a judge, I was therefore conscious and committed also to see to it at the time that the detainees and the accused before my trial courts are protected in their human rights. So one of the duties at the time was to visit detention cells or detention centers. Now, when I became a justice of the Court of Appeals, this became also one of my focus to see to it that I apply the international covenants and also the lessons that I learned during the training when I handle family cases, habeas corpus cases, and also being a division assigned right now to anti-terrorism cases. Thank you po.
You have served as court attorney for multiple Supreme Court justices, each with their own judicial philosophy. How did your exposure to these different perspectives shape your own approach to legal interpretation and decision-making?
I was under two justices, Justice Medialdea and Justice Bellosilio. I would say that they do not have different judicial philosophies. At the time, the Supreme Court is already starting to enter into judicial activism. In other words, the Supreme Court is already interpreting the laws and applying them not strictly to the letter, but also considering equitable justice when in deciding cases. So I was able to witness the transformation of the Supreme Court into deciding cases considering the spirit of the law. So also I was trained in judicial writing because I was able to help also in drafting and research of jurisprudence.
Your extensive experience as a court attorney, RTC judge, and now as an associate justice has given you a deep understanding of the judiciary. In your view, what is the most significant weakness in the current Philippine judiciary, and how would you address it if appointed to the Supreme Court?
I would not say that there is really a weakness in the current judicial system. I would rather call these matters challenges, because I would not say that the judicial system is perfect, but I'm glad that the Chief Justice, our Chief Justice Alexander Gasmundo, has embarked on the strategic plan for judicial innovation. Actually, this helped the judges a lot. In consonance with that, or pursuant to that, to the strategic plan, the Philippine Judicial Academy is also active in the training of judges, and I am privileged and pleased to be a part of that program. And I know that the Philippine Judicial Academy is also able to help your honors in the Judicial and Bar Council in screening of applicants for higher courts. I would say the challenges still are on the continuous training of judges because of the development of the law, the fast-paced also development in technology, and the courts have to be updated in technology in applying this in decision-making. So I think the challenge is still on technology, to continue training the judges on how to adapt to the advancement in the use of computer, internet, online decision-making, expeditious decision and resolution of cases through technology. But I think I'm happy that the Supreme Court is now embarking on such technological innovations. Thank you.
You have been involved in the training of judges and justices through the Judicial Academy. In your view, what are the most critical skills that a Supreme Court justice must possess, and how do you assess your own preparedness in these areas?
Well, in my personal view, and with due respect also to to the other members of the judiciary, I think the most critical is still on the skill, the knowledge and the skill that are needed in correct and valid judicial writing. Well, after about 2 or 3 years, I have been actively involved and being the chair
Involved
also.
in?
Involved in the training of judges and being the current chair of the Department of Judicial Writing. I think it's the application of the knowledge is critical in the actual writing of decisions. So I would say that it's not merely a manual or trivial skill, but judicial writing also involves logic, analysis of facts, and also a deep research of jurisprudence issued by the Supreme Court through the years.
It can be said that our Constitution shares some similarities with the U.S. Constitution. As hopeful to become a final arbiter of constitutional issues, can you pinpoint to us one particular constitutional principle that you will strictly guard against being influenced by U.S. jurisprudence, albeit similarities in our constitutions?
I would say that for me, the most important principle in the Constitution that should be safeguarded is still the Bill of Rights. Although I think there are really similarities in the protection of the Bill of Rights, and I think the Supreme Court, being the department of government or branch of government that is vested by the Constitution to protect and enforce constitutional rights, I think still the Bill of Rights, which has to be safeguarded strictly by the Supreme Court.
With your long years of practice of law and now as an applicant for a Supreme Court justice position, can you share your judicial philosophy?
My judicial philosophy is judicial activism. Although judicial activism in the sense that the letter of the law should not be strictly applied, but the Supreme Court has to also go out and apply equity or equitable principles if the law is lacking because of novel situations or novel cases wherein a strict application of the law may result to harsh consequences or prejudice of substantive rights. So I think because of the program of the Supreme Court, judges have to be proactive in also exploring ways on how to administer justice swiftly and compassionately. Thank you.
Do you have a particular justice here or elsewhere whom you consider an idol, and why?
Of course, my idols are your honors in the Judicial and Bar Council. And of course, all the Supreme Court justices. And because they have
Why
been...
daw? Why?
Why? Well, because the fact that God has destined your honors to be in the Judicial and Bar Council, I know that you have been given such a high and delicate position to choose qualified members of the bench. And since the Supreme Court justices, headed by our Chief Justice, have also been destined by our God to be there, then I know that there is a purpose to fulfill as the members of the High Court of the land.
Assuming you were appointed to the Supreme Court and given the long number of years that you will be there, what do you wish to contribute thereto and to the whole judiciary aside from decision making?
I feel that the continuous education of the, excuse me,
There's water if you need water.
thank you. I think I would like to continue the continuous education of judges, and also that opportunities be given to them to train not only locally but abroad, so that they can be open and exposed also to the development of law globally.
In the context of criminal law, how do you reconcile the principle of nullum crimen sine lege, no crime without law, with the rapidly evolving nature of crimes in the digital age, such as cybercrimes and artificial intelligence-assisted offenses? As an indispensable pillar of the criminal justice system, how could the Supreme Court address the matter?
No crime without law is one of the basic principles of the rule of law. So despite the digital age and advancement in technology, it should remain to be the core principle in criminal law. The Supreme Court has, in fact, issued several rules in order to guide practitioners and members of the bar and bench in interpreting and applying the laws issued by Congress. So through these rules and regulations or implementing rules, judges are able to apply the law and also learn how to be fair in administering justice through the law.
Last question. The principle of proportionality requires that the punishment must fit the crime. How do you view the constitutionality of mandatory minimum sentences which limit judicial discretion? Should the judiciary have the authority to invalidate such laws if they lead to unjust results?
I think penalties in laws are within the jurisdiction of Congress because they are part and parcel of the law. The judge or members of the bench cannot modify or go beyond what is the limit provided by law as to penalties. So if the law gives or imposes a minimum sentence, the judge has to apply that minimum limit. And if the law provides for a maximum limit of penalty, the judge is also required or mandated to observe the maximum limit.
I think the follow-up question is, should the judiciary have the authority to invalidate such laws if they lead to unjust results?
Yes, the courts or the Supreme Court has the power to invalidate a law that is not in consonance with the Constitution, especially as to the Bill of Rights. For example, if the law is a Bill of Attainder or an ex post facto law then these are specifically prohibited in the Constitution, and the courts have the power to invalidate such laws.
That was the last question, but I just have a follow-up question. Have you encountered such law in your years of service with the judiciary?
I have not.
No.
Thank you.
For my own questions, how do you ensure fairness and impartiality in your decision? As a trial court judge, let's start with that. How were you able to practice impartiality in your decisions?
Okay. First, the judge has to present. I'm during my time during the time that I was a trial court judge.
And this is heinous crime court?
Yes.
Yes, please proceed.
I tried to observe due process and also the requirements in the rules of court. So, especially that I handle criminal cases, I see to it that the accused is given at all times the opportunity to air his or her side. For example, during arraignment, I see to it that the information is completely read to the accused, and that the accused is given a competent and effective counsel, even a public attorney who can really defend or represent effectively the accused. I also see to it that both sides, the prosecution and the defense, are given opportunities to present their evidence and not to do away with requirements purely on technical grounds.
What about in the Court of Appeals?
In the Court of Appeals, of course, the parties should be given the opportunity to submit their respective pleadings. Although there are times that cases may be dismissed outright if they appear to be purely dilatory, and if there are instances present, for example, in Rule 65, wherein the petition is patently without merit, then the rules of court allow dismissal outright even without the comment of the other party. But of course, these are exceptional cases.
And you have practiced this in your division now.
Yes, Your Honor.
Cases that should outrightly be dismissed are given attention.
Yes. Your
How do you manage to do this?
Cases wherein there's no need, the court need not require the comment because it would appear to that the petition is purely dilatory, or that it is just a repetition of the same arguments that have already been exhaustively considered by the trial court. For example, in labor cases.
I see. Have you been assigned any high-profile or celebrated case? And please share your experience in handling this case or cases.
In the Court of Appeals,
Anywhere.
anywhere. Well, there are many during my trial court days, since I was I was the judge in the heinous crime. So there are several involving police officers and also government officials who have been charged with criminal cases. In the Court of Appeals, I was able to handle also environmental case, and also anti-money laundering and anti-terrorism case.
Has there been an attempt to approach you, influence you in any way, and how did you handle?
I there was no actual, I haven't encountered an actual attempt, although I have heard that there are plans, but I haven't encountered actual, persons really approaching me.
Please correct me if I'm wrong. In your PDS, it shows that you have never inhibited in any case. Because the answer is NA. Cases wherein applicant voluntarily inhibited. And the answer is NA.
Oh,
What does that mean?
I'm sorry.
Why NA? No,
I'm sorry,
no instance?
I cannot recall any instance that I have inhibited.
In all levels?
I cannot yes, I think
First, second.
I cannot remember any instance that I inhibited.
So this is correct.
Yes.
Okay. What is the bulk of your cases now in the Court of Appeals? What fields of law are usually were assigned to you and pending in your division?
I still have civil, criminal, and special cases. The bulk is special cases. This involve petitions for certiorari. However, I do not have any more cases submitted for decision. I'm happy to have a zero backlog. So I have 200, as of last month, I have 279, all submitted for completion.
Still for ongoing completion?
Yes.
Not yet submitted for
Not
decision?
yet submitted.
So, congratulations.
Thank you.
If appointed to the Supreme Court, how will you interpret ambiguous constitutional provisions or issues that have no clear jurisprudential precedents?
Cases, these are cases that are ambiguous. Well, the civil code provides that courts cannot refuse to render decision based on silent or obscure laws. So I think the court still has to decide based on the evidence of the parties, and there are ways also to apply legal basis even if there are no jurisprudential cases. Like, for example, we have rules of statutory construction wherein we can use the presumptions that the legislature will always enact a valid law that is good for the common welfare of people. There are also treaties and international covenants that can be used as legal basis for those cases. We can also use, just like the Supreme Court, to delve into the legislative history of the law. So we can also use this to resolve actual cases.
You are ranked number 6 in the Court of Appeals, so you are the head of a division.
Yes, Your Honor.
Have you encountered a situation wherein you disagreed with a colleague on a legal issue, and how did you handle such disagreement, if any?
Yes, there are a few instances. But being the chair, we regularly deliberate and we schedule those cases wherein we do not agree on certain points. And I think those instances are always cordial. It did not result to a confrontational or violent confrontational attitudes, but each member was able to discuss and give his opinion, and I think we were able to arrive at the ponente concerned or member considering also the common opinion of of the two members.
Have you had dissents in your decision, in your drafts?
Not yet, Your Honor.
No? Oh,
Yes.
have you dissented in your
I
members?
have. I have.
And what is the outcome? Do they agree with you after discussion, or you have
I
no
think
choice?
it resulted to a division of 5 at the time.
So
But
that
it was-
means they
it
were
was-
not convinced by your dissent.
No,
So you had
the
to have a division of 5.
the ponente has to consider our dissent, so there became a division of 5.
How often did this happen?
Only a few instances before.
Okay. Have you handled labor cases, labor law cases?
Yes, there are labor cases that we have decided in the court.
What is the fourfold test to determine the existence of employer-employee relationship?
Well, first is the control test. If the employer is able to control the terms and conditions of employment of the employee, also the capital test, wherein the employer has sufficient capital to, for example, to pay the wages also of the employee. Another would be the power of the employer to dictate for example, the hours work, amount of salaries, place of work of the employee.
What other power does the employer have over the employee? Powers.
Powers.
Over the employee.
Over the employee, power to, for example, dismiss, power to appoint, and then to dismiss
Yes,
the employee.
That's right. What are the limitations on the power of legislative investigation by Congress to conduct legislative investigation?
Yes. The Constitution vests power on the legislature to investigate in aid of legislation.
What are the limitations?
Well, of course, the limitations would be to protect the rights also of those being investigated. The Congress is mandated to observe respect for your rights.
What else?
The power of contempt also of the legislature is limited only to the period of the investigation. So it should not go beyond the period of investigation.
The purpose of inquiry must be?
The purpose of the inquiry should be in aid of legislation.
Yes. And it's in accordance with the rules and procedures.
Yes, Your Honor.
Under what exceptional circumstances may the writ of habeas corpus be availed of as a post-conviction remedy?
Post-conviction. Habeas corpus as a remedy for post-conviction. I would say that a detainee whose sentence went beyond or exceeded beyond the period of his detention can avail of the writ of habeas corpus.
Or the penalty is excessive? Any
Yeah.
other?
If the conviction is also void, then the detainee or the accused can also, since it's void, then the confinement or detention is illegal, then I think he can avail of the remedy also.
How can that happen? the conviction is void, should it not be raised on appeal? This is a post-conviction remedy, instances wherein the writ of habeas corpus may be availed of when the court has no jurisdiction to impose the sentence and there has been a deprivation of a constitutional right. Are you familiar with the blameless ignorance principle?
I'm sorry, Your Honor.
This is a decision penned by Justice Kagiwa. It has something to do with prescription. Would you have an idea?
On prescription.
Blameless ignorance principle.
I'm sorry, Your Honor.
If the commission of the offense is not known at that time, the prescription begins to run only from discovery.
Okay.
What is the non-diminution rule in labor law?
The salaries,
What cannot be diminished?
the salaries of the benefits
Yes.
already received by the employee should not be diminished.
It's the benefits,
employer,
actually.
yes.
Once given, cannot
Yes.
be removed. You mentioned that you have handled environmental cases. What is the consent decree in relation to environmental cases?
Consent decree.
Yes, it's a decree.
I'm not so familiar, Your Honor.
It's a judicially approved settlement between concerned parties based on public interest and public policy to protect and preserve the environment. So that's my last question, Justice
Thank you.
Fernandez. Good luck to you.
Thank you, Your Honor.
Thank you, Justice Uy. Our next interviewer is the Honorable Attorney Nesauro H. Firme.
Thank you, Attorney Cuevas. Good afternoon, Justice.
Good afternoon.
So how did you prepare for today's interview?
Well, just read some new cases
Okay.
of the Supreme Court.
Sige. If appointed justice, no, to become, by the way, how many times did you apply to become an associate justice of the Supreme Court?
This is my first time.
Your first time, okay. So if ever appointed, what would the stakeholders expect from you?
Well, I will say I will continue to be hardworking and studious in my judicial duties, to try my best to observe the standards of judicial conduct that has been provided in our code, to observe the CIPRA also.
Are you familiar, Justice, with the concept of quantum leap in civil service rule? Quantum leap. Are you familiar with that
I'm
concept?
sorry, Your Honor, I'm not familiar.
Well, it's the concept is all about the appointee cannot take more than 3 salary grades. No? So if ever appointed, no, that appointment will be invalidated unless it would fall under the exceptions provided for by law. So that's the quantum leap. No? The reason I'm asking is, what would be, in terms of policy, do you think it is wise to have or to adopt this kind of policy wherein junior members, no, should, in the Court of Appeal, should be given least preference over a chairman, no, of a division in terms of promotion?
Okay. Now, if I think quantum leap rule would not apply because this will refer to the leap in salary grades. But the junior members and as well as the senior and chairpersons have the same salary grades.
I'm
So,
referring not about the salary grade, no.
okay.
a similar approach, no, policy in terms of application for promotion. No? I understand you are a chairman of the 6th division. So would it be more like a policy, no, internal policy, no, probably an unwritten rule, so to speak, whereby a more senior, like a chairman, would be given more preference over a less, no, or a junior or a senior member?
Yes, Your Honor, I agree with the policy. With all due respect to my other applicants or others who applied, even as senior or junior members, I feel personally that promotions or applications for higher positions should also involve age and experience. So being a junior member means that the junior member is just a newly appointed member. And there are duties that have to be complied in the court before being allowed to apply or being promoted to the higher court.
And in fact, one of the reasons also cited by the or the rationale behind that quantum leap is the possible demoralization of the other applicants. I may have asked you this previously when you applied to become an presiding justice of the CA, no? But I might have missed your answer there. Then you have business interest in Tekimi Corporation and King D Corporation.
I don't have, Your Honor.
Yeah, I'm sorry. Okay, I was about to ask, no, sino may, what takes care of them? Okay. So,
My husband, I think, has a share there.
okay.
But I don't have any direct participation or knowledge in.
I was just asking, what is this business all about?
I am sorry, I
Hindi.
do not know, Your Honor.
It's a privilege, covered by privilege. It's a joke on. Okay. I read your decision, the submitted draft decision. You submitted to the JBC. No? So it's all about the congressional hearing, the resource person was cited in contempt, detained, and there is this case of writ of habeas corpus. So now, the question I would ask you is, when would the principle of purposeful hesitation apply? Or when would the Supreme Court avoid hearing cases or deciding on cases that is purely political in nature? And why do you think that principle is not applicable to the case that were given to you for a draft decision?
Well, I think because of the 1987 Constitution, the Supreme Court is given expanded powers to review or to exercise judicial review over cases. So even if some cases may seem to be political since they involve powers of another branch of government, but when such acts or actions of such department are attended by grave abuse of discretion or lack or excess of jurisdiction, then the Supreme Court may take cognizance of such case. So this is similar, or this is shown by the case given to us.
I was about to ask you that, to probably reconcile the expanded power of judicial review and this doctrine of purposeful hesitation. So now you will become a potential justice of the Supreme Court. So what are the parameters wherein you would apply this principle of purposeful hesitation, and when would you exercise the expanded power of judicial review? What are
Okay.
the parameters? When would you
Parameters.
apply these principles?
Okay. I would say that first, the Supreme Court still applies what we call the doctrine of primary jurisdiction. This doctrine means that a particular office or agency has the primary jurisdiction given by law. And if that branch or office or department fulfills the requirements of that jurisdiction within the bounds of the law, as provided in the provisions of the law creating or vesting powers on the, then the Supreme Court has to exercise judicial restraint and not to take cognizance. But if the actions of such office or department or branch already shows grave abuse such as wanton exercise of its functions that show gross violation of the law that vested powers on such office, then the Supreme Court should exercise judicial review.
So what if there's an equipoise, no? Because, well, admittedly, there is a very thin line separating these two. So what if there is an equipoise between the evidence that, well, probably you're considering it as a purely political, but you know also that there is a grave abuse of discretion. Which which side we're going to take?
Well, I would say that if the substantive rights are involved, then the Supreme Court has to enter and see to it that such actions of the office or branch should be invalidated. But if no substantive rights are prejudiced, I think it's the Supreme Court's duty also to give opportunity to such branch to exercise its own powers.
Okay. So I understand, Justice, you're teaching legal and judicial ethics. Okay, so in a petition for a judicial clemency, no, will you be more lenient to the cause of the applicant petitioner, or you will be more strict, no, in his application, no, taking into account, or strict in his petition, taking into account that membership in the bar is a mere privilege?
I think the petition and grounds and also supporting evidence of the petition for judicial clemency have to be analyzed and studied. If it shows that the lawyer or the judge has indeed reformed, then of course the Supreme Court should give a chance to the lawyer or judge to be reinstated to the bar.
So I heard earlier, Justice, that there were instances that there were cases in the Court of Appeals were outrightly dismissed. No?
Yes.
With respect to the cases against lawyers, can the investigating commissioner also do that? No? Even without requiring the respondent lawyer to file his or her answer? Meron bang outright dismissal power itong si investigating commissioner?
Well, I think the rules, as far as I know, the rules of the IBP require comment from the respondent before any action may be done on the complaint of the offended party. And I I also had the chance before the establishment of the Judicial Integrity Board. I was assigned as an investigating justice, and usually the Supreme Court requires the investigating justice to try the case rather than review the pleadings and impose immediate action.
So you are also aware, no, Justice, that you may be reading some Supreme Court decisions, no? You would notice that in some instances, the Supreme Court are strict in applying the rules. In some cases naman, the Supreme Court is more relaxed. So if you will become the Associate Justice of the Supreme Court, no, under what circumstances will you going to strictly apply the rules?
Well, if the rules provide for purely technical grounds, for example, those rules which go into formalities, for example, forms of pleadings, then if these are purely technical grounds, I think the rules should be relaxed. But if they reiterate or they apply substantive rights, for example, of persons or the accused, then I think the rules should be strictly applied.
So with respect to labor case, no, again, the Supreme Court has different decisions on this. No? Under Article 109 of the Labor Code, it says that every employer or indirect employer shall be responsible with his contractor or subcontractor for any violation. So that's the emphasis, for any violation of the code. So some Supreme Court decision says that this phrase, any violation, no, is merely confined to wages. Other Supreme Court decision says it is much broader. So I'll give you a scenario. No? And this will call for an interpretation for you on your end of what is or how are you going to interpret this any violation. Now, for instance, a company subcontracted the services of a janitorial services. No? Let's say XYC janitorial services. This XYC janitorial services, no, terminated the services of those janitors which are employed, no, deployed to the principal. So the question now is, can this principal be held liable for illegal dismissal when in fact it is the XYZ janitorial services that severed, no, their employment? What would be your interpretation and application of this section or Article 109 of the Labor Code pertaining to any violation of the code?
Well, if there is the indirect or indirect employer or the subcontractor was the one which employed or deployed, then applying Article 109 is really the direct employer which is liable to pay all the wages and also is liable for the dismissal of the employees, not the indirect employer. I would say that since the Constitution is really categorical in protecting labor, the employer, the direct employer, should be liable for all matters affecting the dismissal of the employees, including salary differentials or overtime pay, and even damages as a result of the bad faith, if there is, on the part of the direct employer.
So the principal in this case should not be held liable because yung illegal dismissal was not committed by them. It is the as you mentioned, the direct employer, the agency. Yeah, okay. Because the Supreme Court, as you would see, no, differs, no, from case, no. You also aware, Justice, no, you may be aware that there are some economic provisions of our Constitution. So now, confronted with this situation, no, how are you going to interpret these economic provisions? Will you be more lenient such that you would help, no, the economic growth by allowing foreign investors, or you will be more conservative, no, thereby putting into action the constitutional provision regarding the state policies that the natural resources should be effectively controlled by Filipinos? So how are you going to decide or interpret economic provisions of the Constitution?
I think if I will be a member of the court, the constitutional provision should be strictly applied and enforced. I think the Supreme Court should not have any discretion to be lenient because if, for example, the participation of, for example, foreign corporations is limited to, for example, only 60% owned, no, in certain businesses, then that should be it. The Supreme Court has to apply. It will. The Supreme Court has to wait for a revision of those economic provisions before it exercises its own discretion. But I think the 1987 Constitution encourages foreign assistance only in a limited sense.
Speaking of limited assistance, you're familiar with FTAA, Financial Technical Assistance Agreement.
Yes.
Yes, and you mentioned you prepared for today's interview by reading recent decisions. I think this decision was just uploaded yesterday about the FTAA. It's an ordinance in Mindoro, if I'm not mistaken. No? Well, the question is, what is your understanding of this FTAA, Financial and Technical Assistance Agreement, under the Constitution? This is one of the economic provisions, by the way.
Yes. Well, the exploration of our natural resources should be confined to Filipino citizens or Filipino-owned corporations. And then the state may, however, allow assistance from foreign corporations, but with regard to financial or technical assistance only. This means that the state has to have full control and supervision on the exploration, over the exploration of our natural resources. And Your Honor mentioned the case of Mindoro, and that's why the local government cannot go beyond what the Constitution provides or what the law provides, allowing mining. So it cannot issue an ordinance totally prohibiting mining if the law on mining allows under the control and supervision of the state.
So that is correct. No? If you try to analyze, because there are 3 safeguards no, provided for by the Constitution with respect to FTAA. So number 1, it must be signed by the President. Number 2, the President must report it to the Congress within 30 days from the execution or signing of this FTAA. And number 3 is that it must be, this FTAA must be entered into in accordance with the general law. So the Supreme Court in that case interpreted yung law would not pertain to a local ordinance, but pertains to the Philippine Mining Act. Diba? So last question, Justice. One of the barometers for global competitiveness is the Rule of Law Index. You're familiar with the Rule of Law Index?
a little, Your Honor.
Well, actually, no, we have been measured, no, yung globally, no, through the rule of law index. If we have high rule of law index, it means no, we can get more investors. No, otherwise, no, pag nag-fail tayo, no, the investor would look at it. No, the judicial system is not working, so why would I invest there? So one of the barometers for global competitiveness is the rule of law index. So, and good governance, as I mentioned, is one of the key ways, no, to improve our global standing. So now, as an associate or a potential associate justice of the Supreme Court, so what would be your concrete plans that would particularly involving the principle of accountability, no, in order to attain this objective?
I would say that the new Code of Judicial Conduct should really be strictly applied, wherein not only the Supreme Court will be committed in applying it, but also urging also the other members of the bench, because the judiciary is composed of, we say, the whole team of administrators of justice. So I think for the part of the judiciary, it can share in the implementation of good governance by administering justice swiftly also.
Actually, no, it reminds me of follow-up question. What do you think is the greatest ethical dilemma that confronts our lawyers?
I think even with the enactment of the CIPRA, I have heard that some lawyers do not really strictly abide by the mandatory continuing legal education. I do not have any personal knowledge, but I have heard of reports, especially in the provinces, that they are just merely issued certificates. And I think the challenge there is a strict implementation of the mandatory continuing legal education that lawyers really have to undergo personally, so that they will be updated also, not only with the substantive laws, but also the rules on legal ethics.
Thank you, Justice.
Thank you, Your Honor.
Thank you, Attorney Firme. Our last interviewers, the Honorable Justice Jose Catral Mendoza.
Thank you very much, Attorney Myra V. Good afternoon, Justice.
Good afternoon, Justice.
The last time we interviewed you was when you applied for presiding justice.
Yes, Your Honor.
That's correct. I represent the retired Supreme Court justices, and they have coursed through me their suggested questions. So I'll ask first the question of the most senior, Justice Ascuna. In what ways have your present position prepared you to be fit for the Supreme Court?
I have served, Your Honor, I have served in the Court of Appeals for 15 years now. And this is the first time I applied because I felt that I had to do a good service first to the Court of Appeals. So it's only now that I applied. And I think with my 15 years experience in the Court of Appeals, having gone through all the stages of service, as junior member, senior member, and now chairperson, and I think I have fairly obtained experience in deciding and resolving cases for 15 years. I I've also reached zero backlog, and therefore I think I have done my part also in the program of the Supreme Court in speedy administration of justice. As member of the court, I'm also active in assisting the Philippine Judicial Academy. So through that privilege, I'm also able to learn and update myself in jurisprudence and development of law.
Thank you. Question number 2. What should the Supreme Court be doing differently and why?
Right now, Your Honor, I don't think that the Supreme Court should be doing differently. I would think that the Supreme Court will have to continue to adapt to technological advancements. So it's more on the continuation of its programs in order to also aid the trial courts in their duties.
That was the last question of Justice Ascuna. The next question is from Justice Brion. Is it legally correct to say that our Chief Justice has a more profound influence on law than our President has? Why, and explain fully.
I would say that the Chief Justice is not, I would say that the statement is not accurate because it's not really on the profoundness on the law, because the Constitution itself does not require the President to be a lawyer. So the requirements do not include attainment of the degree of law to become a president. So I would say that since the Chief Justice, the head of the judiciary, that's why his profoundness and his knowledge of the law should be paramount. But it does not really involve a comparison of knowledge and skill between the two heads of the department.
The next set of questions comes from Justice Tiham. Question number 1. Would you consider acquitting a person accused of heinous crimes, plunder, human trafficking, and cybercrimes based on procedural grounds? Explain your answer.
I think my answer will involve still a basic principle in criminal law that an accused should always be presumed innocent until proven guilty. So if this is a basic principle, if procedural law may involve a violation of his substantive rights as accused, then there is a legal or constitutional ground to acquit an accused, even if this involves procedural ground like prescription, because it also delves into his substantive right as an accused. Thank you.
Thank you. Question number 2. Do you agree with all Supreme Court decisions? Explain your answer. What Supreme Court decisions of recent time do you disagree with vehemently?
Right now, Your Honor, I cannot think of a decision that I do not agree with. And I think it's the duty of the lower appellate courts to always agree with the Supreme Court in its decisions.
In the U.S. Supreme Court, there are 9 justices. If, who is considered as the 10th justice? If you know only.
Well, I think it should be the American people should be the 10th.
The answer given is the U.S. Solicitor General. 5. What is birthright citizenship? Is there birthright citizenship under the Philippine Constitution? In your opinion, is birthright citizenship constitutional or unconstitutional? Explain your answer.
Well, I'm not sure of if my understanding of birthright is correct, but if this means that it is citizenship because of the citizenship of the parents, I think this is allowed in our Constitution. But if it is just simply given by the state, then it is not provided, not so provided in the Constitution.
If you know this only, what is the doctrine of Rule of 4 adopted in the U.S. Supreme Court? If you know only.
I'm sorry, Your Honor. I do not know.
Now I'll ask some questions, only few. Earlier you said in preparation for this interview, you read Supreme Court decisions.
Some of them, Your Honor.
Some lang. Okay. Did you encounter any recent Supreme Court decision abandoning earlier established rulings or doctrines?
I think in civil law, I recall Tan Andal case, which abandoned the previous case on Molina, wherein Tan Andal explained the new parameters or meaning of the ground for declaration of nullity, which is psychological incapacity. So it abandoned Molina, which ruled that it can be proven through scientific or medical finding. Tan Andal, however, said that psychological incapacity is not purely medical but now legal ground. And therefore, even without the findings of the doctor or psychologist, but if it can be proven by other evidence, then the petition may be granted.
What else? 2024, 2025 cases, if you can remember. Anyway, you.
in constitutional law, I'm not sure if the Supreme Court really cannot recall a case on constitutional law. Give me a minute, Your Honor. I'll try to remember what I read.
How about the Supreme Court pronouncement yesterday abandoning yes, it was released yesterday by the PIO.
Uh,
The question, the
Oh,
issue there
I
was
know, Your Honor. I don't know if this is on constitutional law, Your Honor, or
yesterday, no,
civil.
the issue was can the Supreme Court increase the penalty imposed on an accused who appeal a case in said
Yes.
court?
Yes, Your Honor.
Oh, you read it?
I don't know if this is the same case, but the Supreme Court, I think in that case, said that upon appeal, i- on appeal, if the accused appeals the decision of the trial court, this means that the case is thrown wide open for review. And the Supreme Court may impose the penalty for the higher crime because it's the accused who appealed. But if it's the state or the Solicitor General is the one who appealed the case or criminal case, then the accused should not be imposed the higher penalty because it will amount to double jeopardy. Is already deemed acquitted by the trial court when the trial court imposed the penalty for the lower offense.
That is correct.
Thank you, Your Honor.
About have you read the Acharon case?
Acharon. About the Vauci
Yes.
case. A little, Your Honor.
What was abandoned there?
Uh,
What was the ruling and what did it abandon?
The Supreme Court ruled there that even in a distinguished first mala inse and mala prohibita cases, that although mala inse involves crimes which are inherently criminal and criminal intent should be proven, Supreme Court said that in mala prohibita, even if the law provides for the crime, there should still be proof that the act was voluntarily done by the accused.
Even if prohibita, even if the intent is immaterial, you still have to prove what?
Intent to perpetrate the act.
Yes, correct.
Yes, Your Honor. Thank you.
So, how did the court categorize psychological violence due to failure or inability to provide financial support? Mala prohibita or mala inse?
Well, this is mala prohibita because through the Republic Act on Vauci, the failure to support becomes criminal if the accused intends to inflict psychological, financial, and emotional suffering on the wife or the spouse. But
That
so,
is the that was the rationale there. But how did it categorize? It is still for you, mala prohibita,
well, because
special law.
it's a special law and the mere failure to support is prohibited based on certain terms and conditions. Because I feel that it's different from the other mala insect crimes like murder, robbery, or
How about psychological violence due to marital infidelity? Mala inse or mala prohibita?
I think also mala prohibita,
Mala
Your
prohibita.
Honor.
Oh. That's where you disagree with the Supreme Court, but not vehemently, right? That will be all, Justice. Thank you very
Thank
much.
you, Your Honor.
Your excuse.
Thank you.
Thank you, Justice Mendoza, and thank you, Justice Myra Garcia-Fernandez. Your Honors, before we proceed, we'd like to acknowledge the presence of retired Chief Justice Diosdado M. Peralta. Good afternoon po, Chief. Your Honors, the last candidate to be interviewed this afternoon is the Honorable Court of Appeals Presiding Justice Fernanda Lampas Peralta. Good afternoon po, PJ.
Good afternoon, Your Honors. Good afternoon, Attorney Cuevas and everyone here.
The first to interview PJ Peralta is the Honorable Justice Erlinda Piñera Uy.
Thank you, Attorney Cuevas. Good afternoon, PJ Peralta.
Good afternoon, Your Honor.
Welcome back.
Thank you, Your Honor.
We remember we interviewed you last year for the position of presiding justice.
I think it was in
2020.
2023, Your Honor,
Ah,
and
yes.
last year I
Right.
was no longer interviewed
right.
for the position.
Yes, thank you for that correction. You have been recently appointed nga, and you assumed the position of a presiding justice in the Court of Appeals last November 2024.
Yes, Your Honor, last November 18, 2024.
May I know what inspired you to apply for Associate Justice in the Supreme Court at this point in time?
Thank you, Your Honor, for that question. Your Honor, the position of an Associate Justice of the Supreme Court is the peak of my dream as a magistrate of the court. And having served the Court of Appeals for 21 years, inclusive of the total of 4.5 months that I have acted as presiding justice, and having served the Court of Appeals as presiding justice since November until today, I think I'm ready to assume the position of as Associate Justice of the Supreme Court. And I'm taking this opportunity because I don't know when the right opportunity is for me to achieve my dream. So I'm applying now. Thank you, Your Honor.
As the current presiding justice of the Court of Appeals, what innovations have you introduced so far in the delivery of justice and in supervising the administrative operations of the Court of Appeals as a whole?
First of all, Your Honor, I'm guided by the Supreme Court's strategic plan on judicial innovations, which focuses on efficiency, innovation, and access. We already have the CAMIS, or the Case Management Information System, and I always remind the employees and the justices to make use of the CAMIS so that we can monitor the status of all the cases. And may I mention at this point that as of December 31, 2024, the Court of Appeals, thanks to the justices and the employees, has achieved an accomplishment rate of 108%, meaning to say that of the targeted case disposal of 14,400 plus, the Court of Appeals has disposed more than that number. And I think that's one of the important innovations, the monitoring of the status of cases. And apart from that, I also focused on the employees by boosting their efficiency through encouraging them to attend flag raising ceremonies and participate in brief exercises or sayaw, which is like Zumba, but it's only for less than 5 minutes. And I think that helps in boosting the efficiency of the employees.
Can you elaborate on the case disposal of 100%?
Yes, Your Honor. Thank you. So, as of December 31st, 2024, our targeted total number of case disposal is around 14,400 plus. But as of that date, the entire court was able to dispose 108% of that. And for this year, for the first quarter, may I refer to my
Yes, please.
statistics? For this year, for only 3 months from January to March 31, 2025, the court has already disposed around 1/3 of the targeted case disposal. And if I may mention the clearance rate also, which is the proportion of the case disposed over the newly filed cases, the clearance rate of the court is 104%.
How did you achieve this, if I may ask? Did you talk to the justices?
I attribute it to the unified efforts of the justices and the employees. And I also send gentle reminders informing them that they have this number of cases which are still for completion. And gladly, some of them send me their reports informing me about the changes in my reminder, meaning to say that some of those cases which have been considered as completed or for completion have already been submitted for decision. So they also send me updates.
Is e-filing already the system of filing in the Court of Appeals?
The filing system, we are
E-filing, not
Yes,
yet?
Your Honor.
Already,
We-
100%?
not 100%, Your Honor, because there are certain pleadings and court submissions which we do not allow yet to be filed through e-filing, like the initiatory pleadings and those with annexes which are amenable to e-filing. But we have the e-filing system now.
To your mind, what qualities do you believe are essential for a Supreme Court justice, and how do you embody these qualities?
To my mind, Your Honor, the essential qualities of a Supreme Court justice is due diligence in the disposition of cases, in the resolution of cases, competence, and speedy resolution of the cases.
Have you handled any high-profile or celebrated case or cases?
Your Honor, I consider all my cases as unique, so maybe I can consider as high profile one environmental case which I handled several years ago, and it was a happy ending because the parties were able to, there was a decision, but both parties were claiming victory. So both parties were happy with the decision, and that case was elevated to the Supreme Court, and our decision in that case was affirmed.
You were the ponente?
Yes, Your Honor. Together, I was the ponente together with my other members.
How was it settled? Was it through amicable settlement?
It was not through amicable settlement, but we rendered a decision, and they were happy with it.
Would you be familiar with the consent decree in environmental cases?
The consent decree in environmental cases, Your Honor, pertains or is akin to a compromise agreement entered into between the parties, usually before the lower courts.
With judicial approval?
Yes,
That's
Your
why
Honor.
it's a decree.
Yes, Your Honor.
Yes. Have you encountered a situation wherein you disagreed with a colleague on a legal issue, and how did you handle, if any?
In a few instances, there was a disagreement, so that colleague dissented. We hold deliberations, but if there is no unanimous vote, then that colleague dissented, and that case was resolved by a division of 5.
After deliberation, still the member dissented?
Yes, Your Honor.
I see. What about the situation or where a colleague on the bench acts unethically? Have you encountered that situation?
I'm sorry, Your Honor.
An unethical behavior of a colleague? Any experience?
I try my best to not to be oversensitive when it comes to those instances. So I must say that right now I have not encountered such unethical behavior.
May I know the bulk of cases that you handled? What field of law this pertain to?
The bulk of cases are appealed cases, varied cases, criminal cases, civil, special proceedings, Your Honor,
Labor.
and labor, Your
So
Honor.
almost all.
Almost
all
all your,
kinds.
yes, Your Honor.
I see. Are you familiar with the Iron Curtain Rule?
The Iron Curtain Rule has been applied in one case involving a child who is non-marital, and it was held that the Iron Curtain Rule must not be applied to that child, and that child should have the right to inherit from his or her grandparents
Would you
by
remem-
way of representation.
Yes, you're using the new term now, the non-marital child.
Yes, Your Honor.
Do you remember the ponente?
It's Senior Associate Justice Leonen.
Yes, he was here yesterday. In labor law, what is the doctrine of strained relations?
The doctrine of strained relations is applied when there is a finding of illegal dismissal, and instead of reinstating the employee illegally dismissed, due to strained relations, that employee is awarded instead separation pay?
What about the blameless ignorance principle? It's a decision penned by Justice Kagiwa. It has something to do with prescription.
I'm sorry, Your Honor, I'm not familiar with that principle.
If the commission of the offense is not known at the time, prescription begins to run only from its discovery. That's why blameless ignorance.
Thank you, Your Honor.
What about the non-diminution rule in labor law?
That means, Your Honor, that if an employee has been enjoying benefits given by the employer, then those benefits cannot be diminished
Yeah.
or taken out anymore.
How about the unavailable child doctrine in a decision on involving child abuse?
If a child refuses to testify in court, then the court will not force the child to come to court, but will still resolve the case.
How about what is the legal remedy available for a person who has been wrongfully deprived of liberty due to mistaken identity?
It's habeas corpus, Your Honor.
Yes. Is the writ of amparo the proper remedy against congressional contempt and detention orders?
No, Your Honor.
Would you remember what case? Very recent case.
Recent case.
It's abroad already, I think.
So maybe that's the case involving Parmalee.
Harry Roque, yes.
Harry
House of
Roque.
Representatives. So that's my last question, PJ. Good luck to you.
Thank you very much, Your Honor.
Thank you, Justice Uy. Our next interviewer is the Honorable Attorney Nesauro H. Firme.
Thank you, Attorney Cuevas. Good afternoon, PJ.
Good afternoon, Your Honor.
I have two sets of questions for you. One comes from the Secretary of Justice. So, I suppose the representative is here to jot down notes. And another set of questions would be my own set of questions. Okay. The first question from the SOJ. You have served as presiding justice of the Court of Appeals since 2024, following a 20-year tenure as an associate justice. Given your extensive leadership experience, can you identify a critical reform you implemented in the Court of Appeals, and how did it impact the efficiency or integrity of the court?
Thank you, Your Honor, for that question. It's very simple for me, but I think it has a great impact because I gave importance to the employees themselves. So when they feel that they are being given importance, they become more cheerful and energetic, and I feel that they are more inspired to work.
Second question would be, you have been part of several international training programs, including those on cybercrime and anti-terrorism. How has your exposure to international legal standards influenced your interpretation of domestic laws, especially in cases involving human rights?
I'm sorry, Your Honor, especially in cases.
Especially in cases involving human rights.
May I request a repetition of the question, Your Honor?
So the question here says that you've been part of several training programs, no, about international agreements. including or commitments, including those that involves cybercrime and anti-terrorism. So the question would be, how has your exposure to these trainings, to these international commitments, no, influenced your interpretation of our domestic laws, especially in cases involving human rights?
Your Honor, it was only once that I have been exposed to a training abroad regarding cybercrime. But may I say that our laws are better than their laws?
This is not part of the question, but in what way our laws are better than them?
In what way
In what way they are better? You said our domestic laws are better than the international laws.
because those international laws are couched in general terms, whereas our cybercrime law is more understandable and couched in specific terms.
Okay. So third question is, you have chaired the Court of Appeals and Bank Sessions as presiding justice. How do you ensure that these sessions are conducted fairly and that all justices are given an equal opportunity to voice their opinions?
Thank you for that question, Your Honor. It was only once that I have chaired the courts and bank session. Before the en bank session, I distributed the agenda. And during the en bank session, there is the transcript of records, which will show that everyone in the en bank was given the chance to air his or her views and to present the committee report for those who wanted to present committee report.
Next question. Given your background in corporate governance and financial law, how do you view the Supreme Court's role in ensuring corporate accountability and protecting shareholders' rights? So would you advocate for stricter judicial scrutiny of corporate practices?
I would advocate not so much on judicial restraint, Your Honor, because there should be a balancing of interests between the fundamental rights of a person and the security or economic security of the government. So there should be a balancing of interests.
Fifth question. It can be said that our Constitution share some similarities with the U.S. Constitution. As hopeful to become a final arbiter of constitutional issues, can you pinpoint to us one particular constitutional principle that you will strictly guard against being influenced by U.S. jurisprudence, albeit similarities in our Constitution?
I would like to mention the Bill of Rights provisions, Your Honor.
What about that, Justice? PJ, can you elaborate on that?
The right to freedom of speech of the press, the right against unreasonable searches and seizures, the right to unnecessary or unlawful arrests. Those are some of the provisions, Your Honor.
Okay. Next question. With your long years of practice of law, and now as an applicant for a Supreme Court justice position, can you share to us your judicial philosophy?
My judicial philosophy, Your Honor, is always to seek the truth, because the truth is the very foundation of the decision, of the application of the applicable law. If a decision is not founded on the truth, then the decision is no decision at all.
Next question. Do you have a particular justice here or elsewhere whom you consider an idol and why? And that includes probably your husband. If he is not your idol, it's okay.
Your Honor, thank you for answering the question for me, and that's my answer.
The question is why?
Because he is my walking legal book.
So assuming you were appointed to Supreme Court and given the, how many years remaining justice, PJ? 3. How many more years are you going to serve?
5 years, Your
Yeah.
Honor.
So assuming you were appointed to the Supreme Court and given that 5 years that you will be there, what do you wish to contribute thereto and to the whole judiciary aside from decision making?
If given the chance, I would like to be part of the committee of SPJI focusing on efficiency of employees, Your Honor.
In the context of criminal law, how do you reconcile the principle of nullum crimen sine lege, or no crime without law, with the rapidly evolving nature of crimes in the digital age, such as cybercrimes and artificial intelligence-assisted offenses? So as an indispensable pillar of criminal justice system, how could the Supreme Court address the matter?
The principle of no crime without law must still prevail, Your Honor, because that is also constitutionally guaranteed. No crime, no ex post facto law or bill of attainder shall be enacted.
Last question from the SOJ. The principle of proportionality requires that the punishment must fit the crime. So how do you view the constitutionality of mandatory minimum sentences which limit judicial discretion? Should the judiciary have the authority to invalidate such law if they lead to unjust results?
May I ask a repetition of the question,
So
Your Honor?
it presupposes the principle of proportionality, which means that the punishment must be proportionate to the crime committed. So the question here is, how do you view the constitutionality of mandatory minimum sentences which limit judicial discretion? Should the judiciary have the authority to invalidate such law as they lead to unjust results?
If we apply, Your Honor, the doctrine on retribution, which means that the penalty need not be applied to a person to its maximum amount if that person has the ability to change for the better. And that's my position, Your Honor.
Okay. So I'll go to my questions, PJ. So you have been recently appointed as presiding justice of the Court of Appeals. So how was your relationship with your colleagues?
My relationship with my colleagues, I cannot classify or I cannot give an exact adjective, but everything is cordial.
So if you are to rank yourself based on, let's say, a satisfaction rating, 1 being the lowest, 10 being the highest, so how would you rank yourself?
It would be very self-serving for me to give a ranking, and may I leave the ranking to them, Your Honor.
Okay. So what is your understanding, Justice, of servant leadership? And if appointed to become an Associate Justice of the Supreme Court, how are you going to carry out this concept of servant leadership?
Your Honor, I will try to abide by the rules of the Supreme Court, and I will do whatever is assigned to me. And as I have mentioned earlier, I want to be part of the SPJI on the program of efficiency of employees. And I will, as I have been doing here in the Court of Appeals, I will always exercise utmost diligence in the performance of my work.
So, reading your profile, PJ, your husband, former Chief Justice Diosdado Peralta, is an independent director of ICTSI, SMC, Manila Hotel, among others. So the question is, would you recuse yourself in deciding or participating in the deliberation of those cases should you be appointed as a magistrate of the Supreme Court?
Yes, Your Honor, I will call the attention of the other associate justices, but I believe that my recusal is subject also to their approval.
So I heard earlier about environmental case that you have decided. So are you familiar with the concept SLAP,
The SLAP,
strategic lawsuit against public participation? So do you think the question now is, do you think that would be applicable also against public officials committing public offenses or graft cases?
Your Honor, the strategic lawsuit against public participation or the SLAP action is available only to environmental cases.
But do you think that concept, would it be a good concept to be applied for those cases involving public officials with respect to corruption so that they would not harass the complainants, filing cases, corruption cases against them? Would it be a good law or a policy?
Maybe it could be the subject of another rule of procedure, Your Honor, not under the...
Yeah, but the concept. But do you think that is a good, so as to encourage people in filing cases and not get intimidated, that later on a case will be filed against them by a more powerful public officers?
Yes, Your Honor, I agree with you.
So you're a certified public accountant. Have you practiced that?
Just for a very brief period of time, Your Honor, because I was then studying. So if there were conflicts with my schedule,
Yes.
I resigned.
Again, you resigned.
When I was studying law, I was also working as a part-time worker. But if there is any conflict with my schedule as a student, I get out from...
You resigned from the work, not
Yes, Your
from
Honor.
becoming a CPA.
No, Your
Yeah.
Honor.
So do you still renew your, I think you have to, just like the MCLE for lawyers, you have to renew. Correct me if I'm wrong, PJ. Is that
I
correct?
pay-
You have
I-
to renew every so often yung,
Yes, Your Honor, but I paid for lifetime membership.
for CPA.
Yes, Your Honor.
Okay. So you still technically, a certified public accountant to this date.
Yes, Your Honor.
Okay. Because the reason I'm asking is I'm going to ask you some about tax laws, which would be a great addition to the Supreme Court should you be included. So what are the two options available to the corporation whenever it overpays the income tax for the taxable year?
The corporation may ask for refund, or the corporation may offset the overpaid amount against the amount payable for the succeeding year.
So what is your understanding, in connection with that, what is your understanding of this irrevocability rule in taxation.
I'm not familiar with that, Your Honor.
So, diba, there are two options given to the corporation. So once the corporation chooses the other, they cannot choose the other one. Yeah. So the next question would be, are input tax required to be directly? There are several Supreme Court decisions about this one. No? So are input tax required to be directly, so the emphasis is on directly, attributable to zero-rated sales in claims for refund or issuance of tax credit certificate?
With regard to that, Your Honor, I have to review again the law, the relevant provision.
It's a recent decision. Election law, you're familiar. This is just a question that popped up, no, among us. No? Familiar with election law, PJ?
I'm trying to, Your Honor.
There is no Supreme Court decision on this yet. No? But I would like to seek your opinion on this. Can a losing senatorial candidate in this just recently concluded election, no, be a substitute nominee, no, of a winning party list? That's, of course, in this same election, because of his passion or her passion to serve the country. So he wants to be a substitute nominee of a party list.
I understand, Your Honor, that the party lists have their own internal rules, and if the internal rules of those party lists allow, then I think that may be allowed.
Would that not violate yung prohibition or otherwise circumventing the law that you have been defeated you did not get the mandate of the sovereign, and yet you will be able to serve but in a different capacity? Would it not circumvent that idea or rationale? If you are going to leave the matter to the party list on how or who should be nominated?
To be safe, Your Honor, they should get another person instead of that one who was defeated in the elections.
I would also like to get your opinion on this. No? In one case, it was, I think, decided in 2023. It's a VAUSI, no? Particularly the psychological violence and the economic abuse provision of this VAUSI. So the accused here filed a demurrer to evidence. Of course, the court finding that there is no really basis, no, to hold the accused for trial granted this demurrer to evidence, thereby dismissing the criminal case. No, the Supreme Court said that the civil aspect of this VAUSI should not be included in the dismissal. Meaning to say, the court has to proceed with respect to the civil aspect, in hearing the civil aspect. Meanwhile, in the case of spouses Wong, in an estafa case, similar case, there's a demurrer to evidence, the trial court granted the demurrer, and likewise dismissed the civil aspect. Sabi ng Supreme Court, yes, that is correct. The civil aspect should be likewise dismissed. So apparently there is I do not know if we can call this as a reconcilable difference between these two rulings. So which do you think is a better ruling? Or this VAUSI case 2023 as against this estafa case 2021 superseded or abandoned the earlier ruling?
For me, Your Honor, there is no necessary abandonment of the ruling because in the Estafa case, the civil action is impliedly instituted, and if there is an express ruling of the trial court, then it has to be sustained. Whereas in the VAUSI, it's governed by a special law, and if there's a provision in the VAUSI that the civil case will remain despite the dismissal of the criminal, then I think there's no conflict with those two decisions.
Okay. So you are also familiar, Justice PJ, of some economic provisions in our Constitution. No? So as a potential magistrate of the Supreme Court, how are you going to interpret the economic provisions in our Constitution? Are you going to be restrictive such that you're going to give life to this provision in the state policies, no, and principles saying that natural resources are effectively under the control, no, or should be effectively controlled by Filipinos? Or you will be more liberal or lenient such that you would allow the foreigners, no, to put their investment here, no, so that to help our economic growth?
Your Honor, if the constitutional provisions are clear as to the participation of foreigners, then the restrictive application, I favor the restrictive application. But if there is no, if the provision admits of interpretations which will be helpful to our national economy, then we go to the other interpretation, which is liberal.
But in case of equipoise, pantay, the interest of both sides, no, would be equipoise. Where are you going to tilt the scale of justice, so to speak?
As long as there is no violation of the fundamental rights of a person, the equipoint may be tilted in favor of the national economy, as long as there is no violation of human rights or the Bill of Rights.
So last question, Justice PJ. So one of the barometers for global competitiveness is the Rule of Law Index. You may be familiar with that, no? Because every now and then there are news articles saying that the Philippines has increased its Rule of Law Index. So this Rule of Law Index, no, is an indication, no, or probably a barometer that investors can now come into our country and invest because we have a good and working judicial system. No. So therefore, compliance with good governance, no, is a key to improve our standing in this Rule of Law Index. So now you will become the Associate Justice of the Supreme Court. So what would be your concrete plans in order, particularly focusing on transparency, no, so that the Supreme Court will achieve or take part in this attainment of Rule of Law Index?
I would like to focus on how to dispose cases speedily, but with due diligence.
That will be all, Justice. Thank you.
Thank you, Your Honor.
Thank you, Attorney Firme. Our last interviewer is the Honorable Justice Jose Catral Mendoza.
Thank you very much, Attorney Myra V. Good afternoon, Justice.
Good afternoon, Your Honor.
Personally, I have no questions for you, but because I represent the retired justices, I will ask the questions course through me. Except that Chief Justice Peralta did not submit. He did not update his Sige. I'll start with Justice Ascuna. In what ways have your present position prepared you to be fit for the Supreme Court? I think you have answered this earlier, but you may elaborate on your previous position.
As I have mentioned earlier, Your Honor, I've been with the Court of Appeals for more than 21 years. And in less than a year, or to be exact, from November to up to this date, I have been the presiding justice. Now, every day I am faced with enormous tasks, but with those tasks that I face, I am proud to say that this is the only time that I experience fulfillment in my work, despite the fact that I face several challenges in my work. And I must also mention that I'm inspired by the employees' response and appreciation for the things, the little things that I do for them. That's it, Your Honor.
Question number 2. What should the Supreme Court be doing differently and why?
Your Honor, for me, I can't think of anything that the Supreme Court should do differently, but it should speed up the completion of the strategic plan for judicial innovations. It started in 2022 up to 2027. And it's doing good because it's already at its version 2 of e-court. The Court of Appeals is just here to follow instructions from the Supreme Court.
The next set of questions comes from Justice Tiham. Number 1, would you consider acquitting a person accused of heinous crimes, plunder, human trafficking, and cyber crimes based on procedural grounds? Explain your answer. If the answer is yes, give examples of procedural grounds which you think are reasonable grounds for acquittal.
May I clarify, Your Honor, the charges against that person?
Heinous crimes, plunder, human trafficking, and cyber crimes.
Your Honor, even if that person is charged with heinous crimes, plunder, cybercrime, and anti-trafficking, that person is also entitled to his fundamental rights. Now, that person may be entitled to acquittal if there is gross denial of due process.
Thank you. Question number 2. Do you agree with all Supreme Court decisions? Explain your answer. What Supreme Court decisions of recent time do you disagree with vehemently?
Your Honor, I agree with the Supreme Court decisions because their decisions form part of jurisprudence.
Okay. A book author once described the judiciary as the most dangerous branch of government. Do you agree or disagree with that observation? Explain your answer.
I disagree, Your Honor, that the judiciary is the most dangerous branch of the government. In fact, no government can, in a democracy, can exist without the judiciary. It would be dangerous if a government has no judiciary.
Number 4, you may answer this if you know, because this concerns the U.S. Supreme Court. In the U.S. Supreme Court, there are 9 justices. Who is considered as the 10th justice? If you know only. In the Philippine Supreme Court, there are 15 justices. The 16th is Timoy. You know? if you know only.
And the question, Your Honor, is,
Justice Tiham. Yeah, the 10th justice of the U.S. Supreme Court, which they consider as the 10th. If you know only, yeah, it's the U.S. Supreme
I'm
Court.
sorry, Your Honor, I do not know.
Yes. The 10th justice, unofficially, is the United States Solicitor General. Yes. Question number 5. What is birthright citizenship? Is there birthright citizenship under the Philippine Constitution? In your opinion, is birthright citizenship constitutional or unconstitutional? Explain your answer.
From my understanding, Your Honor, birthright citizenship is citizenship acquired on account of a person's birth in a certain country. And even if, with respect to Philippine laws, even if that person acquires dual citizenship in another country, he is also recognized as a Philippine citizen.
What is the doctrine of Rule of 4 adopted in the U.S. Supreme Court? If you know only sa U.S. na naman ito.
I'm sorry, Your Honor.
Rule of 4. Do you know what is the doctrine of Rule of 4 adopted in the U.S. Supreme Court?
I'm sorry, Your Honor.
You're not familiar.
I'm not familiar, Your Honor.
Okay. The Rule of 4 is a convention in the U.S. Supreme Court where at least 4 justices must agree to grant certiorari for a case to be heard. Okay. We'll go to the question of Justice Abad. Only few. What rule governs the interpretation of laws when applied to actual cases?
Your Honor, may I say that the rule that applies, the doctrine, I'm not very familiar with, but may I say that when a law is applied to actual cases, then that law must be applied in its text, or no different interpretation should be given to that law.
Apply the literal
Literal
meaning.
application, Your Honor.
Okay. Textual. What area of the law do you feel you can immensely contribute to in its development?
Probably the rules of procedure, Your Honor.
Thank you. We'll now go to the questions of Justice Brion. Is there a difference between strict scrutiny and strict construction?
From what I understand, Your Honor, the doctrine of strict scrutiny is applied when there is danger to the security, whereas in strict construction, it does not necessarily apply to security. Strict scrutiny doctrine applies to cases involving violation of the constitutional right of freedom of expression.
Okay. Explain fully the concept of protected speech and unprotected speech.
Protected speech is the exercise of the freedom of expression with the protection of the Constitution and pertinent laws. Whereas unprotected speech is an exercise which may entail penal sanctions.
Okay, I think that will be the last question, Justice. Thank you very much.
Thank you very much, Your Honor.
Excuse. My last question was the last question of Justice Pirion was supposed to be, Justice Reyes was to be on SLAP, but it was already asked by Attorney Kin. Thank you very much.
Thank you very much, Your Honors.
Thank you, Justice Mendoza. And thank you, Honorable Presiding Justice Fernanda Lampas Peralta. That concludes day 2 of our public panel interview. We will resume tomorrow at 9 a.m. Same venue po. Thank you. Thank you, everyone.